Good afternoon. I'm Eula Clark, Mayor of the City of Stuart, calling to order the regular meeting of the Stuart City Commission, September 27, 2021, 5:30 p.m. here at the Commission Chambers, 121 Southwest Flagler Avenue. And we thank you for coming out today to our regular commission meeting. Clerk, could you please call the roll?
Mayor Clark,
Yes?
Vice Mayor Matheson,
Here.
Commissioner Bruner. Here. Commissioner McDonald,
Here.
Commissioner Meyer.
Here.
As we stand for the Pledge of Allegiance, remember to be mindful and to give thanks and to thank those who serve us, especially as our first responders, and to thank those who are helping with our students during this time. Our Vice Mayor will lead us in the Pledge of Allegiance.
Thank you, Mayor. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Before I go to the individual comments for the commissioners, I just have 2 or 3 people that I want to call out today, especially. So first, I'd like to thank our County Administrator, Ms. Taryn Krisder, for being here. Thanks. And then I especially would like to ask our police and fire members who are present. I don't think any of our chiefs are here, but would you please stand? Police and fire.
Battalion chiefs can stand too.
Thank you so very much. Comments by commissioners?
I wanted
Commissioner Bruner?
yes, I wanted to ask Jim about the Christmas trees that we had last year, and I think it would be just so wonderful and exciting if we could do it again this year. And I think you had planned on it, so if you got anything, maybe you could tell us.
We do. We're
Okay.
actually going to be repeating the event again this year. We're looking at a few other things that we might be adding this year. And I'll certainly, once I get all the things detailed out, I'll make sure that the commission is aware of the dates.
And I wanted to tell Milton, when I called that lady regarding the brick, she was so excited, very happy. We're having to move those bricks for the beautiful trees that what are they called, the yellow ones? Anyway. Those were donated. They were like $200 a tree years ago, and they're being replaced, some of them are there, some of them aren't, and they're being replaced with the purple bloom. And then there's all those bricks will be taken and made a path over at
The band shell.
the band shell. So that it's really nice and wonderful that that's happening, and I want to thank Milton for all that.
Thank you so much, Commissioner Bruner. Commissioner McDonald?
Yeah, so a couple of things. One is, Commissioner Bruner, just on the Christmas trees, that was a program with the Realtor
Realtors, okay.
Association. And I was at their annual meeting, and they were talking about how excited they were to be doing it again this year. So, so it's definitely coming back, and I'm very much looking forward to that too, as well. So, because I think that was a great project and great program, and I think everybody enjoyed it. I know I had a lot of fun judging the Christmas trees. The other thing I just wanted to talk about, the Shepherd's Park ribbon cutting we had. The park came out great. We've had a lot of positive feedback. I know there was a little bit of discomfort during the construction phase, but I think it came out really well, and it was nice to see so many people come out for the ribbon cutting, and the park is much more functional. Next thing is the hallway, the corridor here at City Hall with the new pictures that are up and the painting. I'd worked for many years and asked, and I was unsuccessful at getting that changed around. And I understand that Michelle actually got it done on her own, and I just want to thank her for getting that done, because I think the corridor coming inside the building looks amazing. And kudos to her for getting it done, because it looks great, and everybody that worked on it within the city, and the artist, the photographs are phenomenal, and I think it really brightens up the entry into City Hall. And then finally, just to kind of jump on Mayor Clark's comments, thank you to all the law enforcement and firefighters here in the audience for everything that you all do. Thank you.
Thank you. Commissioner Meyer.
Thank you, Madam Mayor. I'd like to pull item 2 from the consent calendar.
Okay.
And I just wanted to say I do apologize that I wasn't with you all at the last meeting. I was on a plane, actually waiting to get on a plane and watching the meeting taking place, and was able to watch almost all of it. I'm sorry that I wasn't here with you. I was have an excuse. My youngest sister was getting married to her Prince Charming, and I'm so proud of her and happy for her and him.
Where did you go?
I was actually out of the country. I'll leave it at that. But I had a nice time, and but I'm so happy to be home, back with you all, serving the community. Yeah, I wanted to echo Commissioner McDonald's kudos on the Shepherd Park ribbon cutting. Staff did a great job. It was really nice to be able to have so many different organization representatives there to talk about what an effort this was with Find, Orca, Marine Industries, staff. And again, I think the park ended up turning out great. And as usual, our mayor gave a wonderful speech and presentation, and our vice mayor did as well. So I just so happy to see this take shape, and I think it's just a great example of some of the work that we're continuing to prioritize here. So thank you.
Thank you so much. Is that me or is that you?
I guess I'll go.
Come on, Vice Mayor.
Thanks everyone in the audience for being here, police and fire and all the engaged residents. On the topic of Shepherd's Park, I do think it came out amazing. Next step is what we really need to examine is the city-owned property of the Duffy building, as suggested by the Regional Planning Council. Those docks that are leased out are in need of some attention there, and then the whole park will be complete. Speaking of on-the-water topics and looking forward into the future, one thing, it's been a few years, and I think I've been assured that it's happening, but one total assurance is that our officers or our city staff can make sure all the boats in the city limits are properly following pump-out regulations. We are right at the brink with unwanted discharges coming on us from Lake Okeechobee. And so the least we can do is ensure that our own residents are following the proper rules. And I know they are and do believe they are, but proper presence on the water can assist in that. And talking about proper presence on the water and our law enforcement officers, I'm nervous about what I see when I look into the future regarding Brightline coming down and the meeting that I got to take part in and a lot of the Marine Industries Association did a few weeks ago here in the chambers. And I know Chair Stacy Hetherington sat in from the county, and Brightline is planning to come through the first quarter of 2023. And that bridge, if all goes to their plans, will be down 45 minutes of every hour. And we have that 15 minutes where it's open to thank Martin County's litigation with them for. But, having grown up here on the water, I am incredibly fearful of the safety issues that's going to lead to, on a nice sunny Saturday or Sunday or Memorial Day weekend or something, when you have hundreds of boats piled up on either side of that bridge wanting to get under. And so that's why I want to stress that our officers need to start thinking about that now and those safety issues and kind of have a long-term program of a good, solid on-the-water presence in that area. has a real potential for safety issues when Brightline's coming through and that train bridge is down. Again, on the water issues, I am going to be working on behalf of the city and the Indian River Keeper Board to take one of the South Florida Water Management Governing Board members, hopefully out on the water for a tour of our river, October 6th. So we'll do our best to show her the waterways and, you know, explain where naturally the water should be coming from and give her a first personal view of what we did to alter it. And I'd be remiss without saying that some news came out today of cyanobacteria located at the S80 structure. For all summer, it's been located at the C-44 canal closer to the Port Mayaca side. That's really all I know at this point. The health department came out and made a statement about it. But it's there basically on our side. And even though for past, you know, most of the summer, almost all of it, we haven't received lake water going into the C-44 canal. Boat traffic, your everyday boat traffic brings water in and out. And for all extensive purposes, the water in the C-44 is very similar in properties to the water in Lake Okeechobee. So, you know, we're in a dangerous spot, especially if we get a hurricane anywhere south of Orlando with unwanted discharges coming down upon us. And in the effort of brevity, I'll leave it there.
Thank you so much, Vice Mayor. I'd like to pull item number 5 because I've asked City Manager to just briefly talk about just the fees and so on, just very briefly, for those who are either watching by Zoom or in the public, and just to point out to the public where they can find more information in the code when this gets codified as to the changes and so on. So that's item number 5, just for a brief explanation. On October 7th at 6 p.m., there will be a workshop at the 10th Street Recreation Center with regard to a plan from A1A down to Tarpon Avenue with regard to improvements to the Martin Luther King Jr. Boulevard. And we're asking persons who are interested in our City of Stuart and what happens in our City of Stuart, in our various communities within the City of Stuart, to please come out, give your input, or call ahead of time, speak to Pinal Gandhi Savdas at our Development Department. Get as much information as you want. Don't wait until that evening to ask all your questions. Call ahead and ask your questions, or call Michelle Vickett at the City Manager's office, and we'll get you all your answers and get you any pictures or drawings or any consultant reports that you need before that meeting so that you can be well informed at that public meeting regarding Martin Luther King Jr. Boulevard. With regard to our Vice Mayor, I hope it's our Vice Mayor, who does the Hobgoblin Parade?
Vice
Stewart
Mayor.
Main Street and the Vice Mayor.
Vice Mayor, that's what I thought. I just dreaded. I didn't want to do it. No, I'm just kidding. You have children. It's an honor. It's an honor. You love it.
The discussions we've had in the past few weeks on who's going to be what, I've gone from Goofy to the Big Bad Wolf to anything. You know,
One more.
whether it's helping my children or the kids, I'm happy to dress up as whatever.
Thank you. Hobgoblin Parade you can get with Ms. Callahan for that. And in that regard, I'd like to, for City Manager, to thank Ms. Callahan and the Main Street Group for what they're doing to really continuously keep Stuart on the map, keep our downtown on the map, the innovative ways that they're working. We really appreciate it, and we appreciate what they're doing. I'll just say ditto, ditto, ditto regarding the ribbon cutting in Shepherd's Park, but I must highlight Mr. Kralski, Mr. Tim Volker, Mr. Leggett, and everybody, our consultant, Ferreira Construction, and everybody who had a part in doing Shepherd's Park. It's old, it's probably one of our oldest parks, and we want you to go see Shepherd's Park, and if you have a boat, of course, the whole boat ramp has been revamped, and we just want to really, Mr. Kralski, we really appreciate the work that your department is doing with all of our parks and for coordinating the work at Shepherd's Park. We appreciate that. We appreciate everything that our engineering department has done and everybody, because this is a team effort with our City of Stuart. We also appreciate the work that you're doing with publicity on the various improvements to East Ocean Boulevard, to Osceola Street, and all the things that are happening and on the US 1 corridor. We really appreciate that. So we thank you. Commissioner Bruner, thank you for bringing that up, and Commissioner McDonald, thank you for, having the realtors who are going to do that Christmas tree in the park again. And if we could extend that, Mr. Kralski, if you could find some other places to extend it to, we'd love to do that. If we could have some trees, have somebody enter into a competition, do some stuff around the 10th Street Rec Center. It's one of our biggest rec centers. Maybe if we could have something, one nice tree at the Shepherd's Park. There's a nice little foundation area there. So if we can be creative, because there's so many people, Ms. Howard Diaz, who knows a lot of community partners who can get us some things going for the season. So we really, really appreciate that. City Manager, I've talked to you before about the shuffleboard court and how we can try to get some improvements over the next couple of the years there at the shuffleboard court, and maybe make it a viable rental facility for our city. So if we could look into that and kind of give it a spruce up and a facelift in our budget in the future, we'd appreciate that. And I'd like for City Manager, when he gets to his comments, if you want to at this time, if you don't have the information, you don't have to, but if you want to just mention to people about the potential underground project, Osceola Street, or not, if it's not going to happen right now, but some people might be anxious, and if you know any information on how that is going, you could tell us that. And so that's about it. I think I'm pulling item number 5, and I mentioned that. I don't think, okay, the CRA, we just had a CRA meeting where we talked about a form-based code, especially for the East Stuart area and the Creek District, and we are looking for input on that. There's a consultant with the Regional Planning Council, and we want the community involved. We want people to get their ideas out there, because when redevelopment comes, we want it to be the kind of thing that people are going to be proud of and want to live next to, and want to bring their family and their friends when they come into town and say, this is where I live. So we want to make sure that everybody get involved with that project as we move forward with it. Comments by City Manager.
Yes, ma'am. FPL has agreed to hold off on switching the poles out in downtown as long as we're going to move forward, and they're going to coordinate with us on that. And so today I gave the CRA the direction to engage with our designer consultant to move forward with the underground designing for downtown, for the Osceola section. The other section's already done.
Excellent.
Thank you.
Very good.
We have an agenda in front of us with 20, how many items?
If I,
23.
before we start the agenda,
15.
if I could just make 2 quick announcements as well.
Okay, yes, thank
Over
you.
the since our last
Mike, talk
meeting,
in your
Sorry,
microphone.
we can't hear you.
hello?
There we go.
Since our last meeting, the city received a petition for an administrative hearing challenging the process and procedure used by the city in doing a future land use map. It's titled Cartwright versus the City of Stuart. It will be taking place as a public hearing in the form of a trial, November 15th, 16th, and 17th in City Hall. For right now, that conflicts with the Rivers Coalition meeting, which will be one of those days that would take place in this. In the event that it does take all 3 days and it would conflict with it, it's my intentions to make other arrangements for the hearing to be in a different location within the City of Stuart, or maybe even use a Stuart Day at the Stuart Main Street matter, but we'll address that as we get a little closer once we have more information. In addition to that, North Stuart Acquisitions filed a lawsuit against the city. If you recall, this was the North Point sales agreement that in the contract it mentioned the other lawsuit and the issue, but the wherefore clause in the complaint just going to read it so we're all on the same page. It says, wherefore North Stuart Acquisitions requests the court resolve the issue concerning the rights of the parties related to the memorandum of lease recorded in the public records in the lawsuit of 2017-73, and then upon determination of that memorandum, address North Stuart Acquisitions rights and remedies. And as those of you that were on the board at the time, or those of you that reviewed the contract actually had that lawsuit mentioned in it, was excluded from it, and scheduled the closing to take place either 30, 60, or 90 days following the approval of the development order. And when they were supposed to close in that July, that memorandum of lease, they said, was an issue because of that lawsuit, even though it was disclosed. So we'll be defending that at such time as some discovery is done and I have more information, because honestly, other than the pieces of paper, I don't have any new information to discuss with you as it relates to both the petition for administrative hearing as well as this complaint, other than I got an order from the judge scheduling it for November 15th through 17th. But I will schedule a shade meeting for both. The administrative hearing does allow us to go to mediation. I sent an email to the lawyer on the other side asking what their demand was to see if there was something worth going to mediation over. Obviously, need to know that before I schedule a shade meeting, because I can't get authority if I don't know what it's for. And then as it relates to this case, again, once I have information, I'll schedule that as well.
Thank you, Mr. Mortel, and I think I'd ask you if there were any other lawsuits with the city of Stuart that we needed to just keep abreast on. So if you could send us in writing so that we can know, or even, you know, when you talk to us, so that we can keep track of everything. But those two new ones are important, and we look forward to you sending us that information. Is there any other comment by city manager or anybody else?
I'll motion
Vice Mayor?
to approve the agenda, pulling items 2 and 5 from the consent calendar.
Second.
Okay, there's been a motion by Vice Mayor Matheson, seconded by Commissioner McDonald, to approve the agendas published, pulling items number 2 and 5. All in favor?
Aye.
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 Aye. The motion is unanimous. I didn't hear Commissioner Bruner's voice.
Yes, aye.
Okay, thank you. The motion is unanimous, approved unanimously as requested by the Vice Mayor. Comments from the public, we have 3 minutes. Rules of civility are in effect. And of course, we appreciate everybody's comment and input. Mr. Menage, I can't pronounce it. Thank you, sir.
Thank you, Commissioners,
Yes,
for
sir.
hearing our plea. I've been down here about 50 years. I've lived on the same street in the same house, and it's Lanita Street. I
Yes,
don't know
sir.
if any of you are familiar with Lanita Street, but it's 2 blocks long. It runs from Colorado Avenue over to Casa Street.
Yes, sir.
That's kind of a speed thing. People turn on Colorado Avenue and think they're going to beat the stop sign going back to US 1, and we have excess of speed. All our neighbors complain about it. I had 4 or 5 petitions that I went ahead and took over to the city and says, please, please, we need speed bumps, and we need our street repaired, because there's no storm sewers on Lanita Street. It becomes a lake when there's any kind of heavy rain. And we have 2 new gentlemen here that just moved into the neighborhood that are fantastic neighbors, all right? And one lake is in front of my neighbor's house, which is right to the left of me, I believe. But it's a beautiful street, and we have beautiful people living on this street. And it seems like we could get storm sewers. There's storm sewers on Isla Street. There's storm sewers on Villa Street, but no storm sewers on Lanita Street. And it's one of the oldest streets in Stuart. I believe my house was built in 25, so it's an old neighborhood. But we sure would appreciate it if somehow the commission can do something to repair the street and get a storm sewers, that we're not always flooding out because my house, being the first one that was built there probably, all right, is the first one to get the water, all right? And I thank you. These are my two neighbors, all right? One lives to the left of me and the other one lives right next door. Both of them are new within a year of coming to the ministry. We love the neighborhood, we love the people, and we love Stuart.
Thank you.
Thank
And
you
without,
very
without
much
taking
for
any,
having us in Stuart.
without taking any time from you, would your neighbors please say their names so that we can welcome
My name is
you?
Richard. My last name is Manage, Maneage.
Thank
all
you.
right? My address is 232 Southeast Lanita Street. all
Thank you.
right? I've got about the only Spanish house on the block, all right? Because that's the way the architecture was going way back then, all right? But I think it's a marker because I don't think there's too many houses that are going on 100 years old over there, all right?
Thank
And I
you.
would appreciate if the commissioner can somehow take it into their, and somehow do something for us, all right? Because we have a lot of small children, and we also have a lot of people that have animals.
Thank you,
And we
sir.
would hate to see some of them getting killed.
Thank you, sir.
Thank you.
Neighbors, could you introduce yourselves, please?
Kenneth Jordan, I live at 228 Southeast Lanita.
Thank you. And, sir,
June Champagne, and I live at 226 Lanita.
welcome to Stuart. Thank you so much.
I've lived in Stuart most of my life,
Thank you.
but I just bought in town. I usually lived out west of town.
Thank you, sir. Thank you. Next, we have Mr. William Rudge.
Madam Mayor, while he's getting up,
Oh.
if I can just jump in. That reminds me, I had a brief discussion with Joe Capra at the ribbon cutting, and looking forward to the City of Stuart will be reviewing a new stormwater master plan here coming very soon that'll have recommendations for massive stormwater upgrades throughout the entire city, so.
Thank you. Mr. Rudge?
Good evening.
Yes,
Can you hear
sir.
me? Okay. My name is William Rudge of 1701 Southwest.
can't hear.
Right into the mic, sir, or up, yeah.
I'm trying. My name is William Rudge of 1701 Southwest Palm City Road, Stuart, Florida. I have been a permanent resident of Stuart for over 20 years. My daughter was born here, and my family has been here for more than half a century. The last time I was at a Stuart City Commission meeting, about a month ago.
We can't hear you, Mr. Rudge.
The last time I was at a Stuart City Commission meeting, about a month ago, I asked this commission some questions that has still not been answered, addressed, or even acknowledged as of yet. First, I would like to thank someone for finally posting the July 29th Budget Workshop number 2 on the city's website. I have no idea why it took so long. Perhaps the city's IT department could use some assistance. At least we finally have an accurate depiction of the actual proceedings, unlike the not so entirely accurate piece in the Stuart News. The unanswered questions of 1, why is this commission and this city still paying an attorney who consistently, repeatedly, and still lies to, deceives, misleads, and misrepresents this very commission, as well as the 19th Judicial Circuit and the 4th District Court of Appeals? Why doesn't our commission know they are being deceived, or even care to check it out for themselves? Also, last month, we all watched as newly elected commissioners took a solemn oath to uphold and defend both the United States Constitution and the Florida Constitution. I still want to know why one of them wanted to find out how to break a citizen's Article 10 of the Florida Constitution homestead protection rights in a special city commission meeting. One of the very things he swore an oath to uphold and defend. You know who you are, sir. I just wanted to know why you would try to do such a thing to one of your constituents. And so I have all these questions about my city commission and my city commissioners and their activities. Who is accountable for answering these questions? If I don't have a right to ask these questions and demand answers, then I have to ask each and every one of us just exactly what shape is our republic in, with liberty and justice for all. Amen. Now I would like to know who it is I can expect these answers, as well as some others, from. That's my 3 minutes. Thank you.
Thank you, sir. Mr. Brinkley?
Yes, I want to thank y'all for the opportunity to stand before you, but I was out exercising this morning, and I ran into an issue on Martin Luther King Boulevard and Bayou near the daycare center. That was a scary situation that I seen this morning. Instead of me exercising, I stood there 30 or 40 minutes directing traffic there because people were so scared to get out on Martin Luther King Boulevard because vehicles is parked there in the parking lot where they cannot see with traffic coming. And mind you, Martin Luther King is a speed zone, in case you all don't know that. I spent 30 or 40 minutes there. People were scared to come out there, to get out on the road. You got school buses, you got vehicles coming through there. People were afraid. You got a young lady that stayed 2 houses from there. She rolled down her window and said, Mr. Abbott, I'm so scared to come out here. They cannot see because vehicles in the parallel parking lot. Then you got 2 palm trees that's there. People was rolling it down. They wasn't thanking me. I didn't even worry about walking no more because it scared me because I've been in the same situation on my end, which is Central Avenue, where I almost been T-boned when the drug rehab house was there because I couldn't get out. I see these people facing the same thing coming from the daycare center. That was scary today, y'all. That was scary, and that shouldn't be. People was afraid to come out. They let down. They weren't thanking me for directing them out there to get out on the road. You could only see from east. West, you can't even get out. I was standing up, and I couldn't see the vehicles coming from the west. That is scary, and something needs to be done about that so something seriously happens. Because, like I said, on my end, when the drug rehab was there, I almost got T-boned a couple times trying to get out there. Something needs to be done. Because something happens. You got people coming from the daycare center, and you got regular people using that road. Then you got the school buses open right there that's got to come out too. People was really scared to come out, and I'm standing there looking. I couldn't even see the vehicles coming from west. I couldn't, and I'm standing up. The people was afraid, and they were literally let down. They wanted thanking me for directing them out to get out on Martin Luther King Boulevard. That was scary, and something needs to be done about that. And like I say, Martin Luther King is a speed zone. Last week, I pulled into a parallel parking to talk to someone. I was literally scared to get back in my vehicle because people was flying down Martin Luther King Boulevard, which is basically every street now in East Stuart, even on my street, people speed. Top Pond, 10th Street, I don't know what it is, it's a speed zone. And that's scary on Martin Luther King Boulevard with these people saying, Mr. Albert, thank you. They were literally afraid, y'all. It's time for something to be done. You got the 2 palm trees, and then you got vehicles parked in the parallel parking.
Thank
That
you.
was scary.
Thank you, Mr. Brinkley. Thank you so much. And I know that you brought that. City manager is going to be dealing with it. and,
Madam Mayor, the blocks will be put in tomorrow morning, according to Milton, to free up that space so you can see to the left.
Thanks.
Thank you.
Thank you. We have the consent agenda. We've pulled item number 2 and item number 5. What is it?
Move for
what-
approval.
Move for approval by Commissioner McDonald. Who's the second?
Second.
Second by Commissioner Bruner. This consent agenda has items in it that are related to money, so I think we'll need a roll call, clerk.
Yes, we do. Commissioner Bruner,
Yes.
Commissioner Meyer,
Yes.
Commissioner McDonald,
Yes.
Vice Mayor Matheson.
Yes.
Mayor Clark.
Yes, ma'am. Item number 2, the Adopt the Triangle District Master Plan and designating a name. Do you want to read that, city manager?
This is resolution number 74-2021, a resolution of the City Commission of the City of Stuart, Florida, approving and adopting the master plan for the Triangle Study Area and designating the name of the study area as Triangle District, providing an effective date and for other purposes.
Commissioner Meyer?
Thank you, Madam Mayor. I really just wanted to pull this for the benefit of the public that might be tuning in now. I know we just went over this in our CRA meeting, but you know, for those of you who are, who were here or are here now and are tuning in online, this is a large project that we've been working with the Regional Planning Council, the result of public input sessions, walking tours, and is a great step forward in us visioning what the redevelopment opportunities are for the Triangle District, which is right over here across the tracks, bounded by US 1, Joan Jefferson, and West Ocean. And really exciting ideas coming out of this, with some potential traffic changes, streetscape improvements, and art corridor. So I encourage everybody to take a look at that really, really thorough and well-done master plan. And we're officially naming the area. If this motion and seconded, we'll rename it the Triangle District once and for all.
Thank you. Any other comments from any commissioners on item number 2?
None.
Any comments from the public on item number 2 regarding the Triangle District Master Plan and designating the name for the Triangle District?
Motion to approve Resolution 74-2021.
Second.
Okay, motion and a second. Do you have that, clerk? You know the name, the motion by Vice Mayor, seconded by Commissioner Meyer. I asked for public comment already. Roll call, please.
Vice Mayor Matheson,
Yes.
Mayor Clark,
Yes.
Commissioner Bruner,
Yes.
Commissioner Meyer,
Yes.
Commissioner McDonald.
Yes.
City Manager, I pulled item number 5 just for you to give us a brief synopsis of these fee structure at the City of Stuart.
This is Resolution 100-2021, a resolution of the City Commission of the City of Stuart, Florida, adopting Appendix A by amending Chapter 12, Chapter 22, Chapter 32, Chapter 34, and Chapter 42 of the city's Code of Ordinances and providing an effective date.
Yes, Madam Mayor, we update our Appendix As annually prior to the October 1st date to coincide with our budget. On occasion, it gets updated if there's another pending change that is urgent that needs to be done, but at the minimum annually, we examine these fee rates. And so all the different chapters within our code, if there's a fee in them or a rate in them, they refer to our Appendix A, which outlines all the different fees for the different sections of code. So running down this real quick, Chapter 12 changes relate to towing and storage fees as it relates to calls by law enforcement to have vehicles towed. And Chapter 22 relates to fire fee rates and inspections of like tents and so forth. Both Chapters 12 and 22 were changed to coincide with the communities around us, specifically Martin County and what they're charging for their rates and fees. Section or Chapter 32 is the fees from the Development Department, and those are changed through a resolution that was adopted by the commission a long time ago to set those with the consumer price index increases. So those are going up by those increase rates for CPI. And then chapters 34 and 42 revolve around water, wastewater, and sanitation rates. And the commission adopted a study in August 14th, 2017 to increase those rates annually by whatever percentage within those individual funds that were required. I believe this is the last or second to last year of that 5-year cycle, and in 2022's fiscal year, we'll be doing another analysis for that rate study, which will be coming back to you towards the end of 22.
Thank you. Any commissioners have any comments on item number 5?
Move to approve.
Second.
Moved by Commissioner McDonald, seconded by Commissioner Meyer. Any comments from the public on item number 5, adopting Appendix A, fees and rates for the City of Stuart? City Clerk?
Commissioner Meyer,
Yes.
Mayor Clark,
Yes.
Vice Mayor Matheson,
Yes.
Commissioner Bruner,
Yes.
Commissioner McDonald.
Yes.
Yes. Before we go on, this is the end of the consent agenda. Before we go on to commission action item, I don't know if she's here today, Roz Johnson, our personnel person. This would be the day when she's not here. But this consent agenda contained a lot in it. And through the work of our union partners, our fire union partners, our police union partners, and our personnel department, a lot of work and a lot of negotiations goes into what they do in order to continue to do their job, to have an effective city, to have an effective base. And so it is so important, and I just want to congratulate our personnel department, city manager, and of course, our partners in the union, the police and fire unions, of the things that they've done so we can move forward another year and have a successful, effective work going on within our city. And we just want to thank you so much to them. Thank you. Thank you. Commission action. Authorization to sell the Old City Landfill property. Resolution 69, 2021. Mr. Mortel.
This is Resolution 69-2021, a resolution of the City Commission of the City of Stuart, Florida, authorizing the sale of the Old City Landfill property and authorizing the city manager to enter into and execute a vacant land contract with the purchaser, Goldstein Kite Environmental LLC, and/or assigns, providing an effective date and for other purposes. This is essentially an unsolicited offer that is legal pursuant to Florida statute, as we are a municipality. And they have a presentation. The Goldstein Kite Environmental is here to present.
Okay, is that going to be anybody from development or just Mr. McCarthy? Okay.
Good evening.
Yes,
Can you hear
sir.
me? Thank you. Good evening, Mike McCarty with McCarty and Associates Land Planning and Design. I'll just take a brief minute to speak with you, and then I'll introduce Michael Goldstein, Kelly Kite, and their team. I'm a seventh-generation Florida native. Been living here all my life. Went away for school up in Tallahassee at Florida State University, and during my interim in Tallahassee, worked for the Department of Environmental Protection for a stint of time. When I came back home and started working for some of the local land planning firms, I was always perplexed when I drove by this site and saw it laying dormant in our urban core, if you will, of the city. And it's been like that for almost 50 years or more, I suppose. You know, in the private sector, I've been practicing now for 15 years. It's always been an interest of mine to try to figure out how we can make something happen with that site. I know that numerous entities or individuals have approached the city over time and considered acquisition of that site in forms of redevelopment. I've spent numerous years working to try to find the right fit for that project, being that it's a landfill and has significant environmental issues. I started doing some networking through people that I've worked with and through researching and so on and so forth, and was able to contact Michael Goldstein and Kelly Kite. I introduced them to this site. We researched it on our own for a number of months prior to actually coming to the city and meeting with Mr. Dias and Mr. Mortel and Kev Freeman and even members in Public Works. You know, the city has an albatross hanging around their neck. We have an environmental catastrophe that we all just act like isn't there. And it's time that we do something about it. And I've taken the initiative to go out and solicit the appropriate group that has a successful track record and an amazing list of experiences that they're here to share with you tonight. And it's a way that we can get this property off of the city as a liability and move it forward to providing jobs, tax base, and redevelop an environmental catastrophe that's a ticking time bomb. So I introduce to you Michael Goldstein and Kelly Kite.
Thank you. Mr. Goldstein, you have a presentation, sir?
Yes, Madam Mayor. Madam Mayor, Mr. Vice Mayor, Commissioners, Charter Officers, my name is Michael Goldstein. My address is 2100 Ponce de Leon Boulevard in Coral Gables. I am a principal with Goldstein Kite Environmental LLC. I'm here with my partner, Kelly Kite, also with Goldstein Kite Environmental. Kelly?
Kelly Kite, Vero Beach, Florida, 2735 Carissa Avenue. Happy to be here with Mike presenting today. I really want to appreciate all your time. I know we've met with each of you individually, particularly Mike Mortel and David Dias. Mike spent a tremendous amount of time protecting the city's interests going over this, and so I really appreciate it. And thank you for having us.
Yes, sir.
This is an important opportunity. We've been treating it as such. We have a lot of information to go through. We'll try and go through it quickly. I hope we've anticipated your questions. I think our proposal responds to the moment. Mike, who introduced us, spoke to the importance and significance of the site, and I think what we bring to the table. Got it? There we go. Okay. Commissioners, the first thing I want to stress to each of you and to the residents who are watching us, who are here with us today, that we bring to the table a first-class team of sophisticated redevelopment professionals. I feel that we have a best-in-class group here to serve the city's best interests, to serve the residents' best interest, and to bring this site quickly back into productive use, to put millions of dollars into the tax rolls through the marshaling of between likely $200 to $400 million in capital investment, the creation of thousands of jobs, part-time jobs for construction and for cleanup and redevelopment, and thousands of permanent jobs depending on the reuse here. Goldstein Kite Environmental is a brownfields redevelopment firm. We specialize in project management and financing and development approvals and reuse on challenging, contaminated sites. I've been at this for 30 years. Kelly has been at this for quite a period of time as well. We bring unique talents and experiences to the table. We're going to talk about that in some length. We have 3 national environmental consulting and contracting firms that collectively have worked on not dozens, but hundreds and hundreds of landfill redevelopment projects all across the country. This is the A-team that we're bringing to the table. This is not something that any of us has dabbled in. This is what we do day in and day out. It's inherent in the DNA of our various corporate entities. We're also partnering with Kimley Horn & Associates. Kimley Horn & Associates is one of the top civil engineering firms in the United States. We're going to talk about exposure to environmental liability in short order. We're concerned about our exposure. We're concerned about the city's exposure. We feel we have a very good insurance solution. We're using what I think is the best-in-class environmental insurance agent in the United States. I've worked with them for over a decade now, placing hundreds and hundreds of millions of dollars in environmental insurance on risky sites throughout the state of Florida. And then finally, we're working with a modest environmental law firm called the Goldstein Environmental Law Firm. That's what I do in my day job, representing local governments, private developers, not-for-profits, community advocates, environmental justice advocates. I've been in this business for 30 years, and we've done more of this type of work than any other law firm in the state of Florida. We're going to get into that in some detail in a moment. Just a very brief note regarding Kelly and myself. Again, I've been doing this type of work both as a lawyer and a redevelopment principal for almost 30 years. In the Florida Brownfields program alone, I worked on over 200 projects from Pensacola to Jacksonville to Key West to Sarasota and Orlando and all points in between. Just within the Florida Brownfields program, I've worked on more than 40 landfill redevelopment projects as a trusted counselor. We're going to talk a little bit about what we've done as GKE, as an environmental redevelopment principle, bringing landfills back into productive reuse. My partner Kelly has been working on distressed real estate for at least 15 years and has mobilized over $250 million in private capital into these types of assets. If you go deeper into our resume, you'll see that we are committed to this type of work nationally on a statewide basis and locally as well. I was one of the initial advocates and legislative supporters of the Florida Brownfields program in 1997. I participated and the drafting of the legislation. I've been very involved in national environmental policy, environmental redevelopment policy, and environmental justice-related initiatives. I was recognized for my involvement as such back in 2019 by the Southeast Brownfields Conference. Kelly, my partner, is also very involved locally in environmental issues as well as real estate issues. As just one example, he serves on the board of the Indian River Land Trust. I want to move now quickly through several case studies which inform what we have here in the City of Stuart to give you a level of confidence that this is not our first rodeo. We've worked on very challenging sites before that have similar DNA to the site that Stuart has and hopefully will bring back into productive reuse in short order. The first project I want to talk to the Commission about and to the residents who are listening to us here and online is a former landfill site also owned by a municipality in the city of Coral Springs. City of Coral Springs owned this 16.2 acre site. As you can see, just like the City of Stuart site, it is in the middle of a highly dense, developed neighborhood with lots of residential and mixed use. This was a site that was subject to ongoing enforcement. Like the city site here, the City of Coral Springs site had a consent decree with, the City of Coral Springs had a consent decree with FDEP. Unlike the City of Stuart, Coral Springs wasn't complying with its obligations and was about to be sued under state and federal law by the county. County was administering the state and federal cleanup regulations. We came in, acquired the site, and entered into what's called a Brownfield site rehabilitation agreement. That's a strategy we're proposing here. The Florida Brownfields program provides incentives for developers to collaborate with regulatory agencies as opposed to resist enforcement. We stepped up to the plate very quickly, and in short order, we were able to get an NFA letter from the county on behalf of the state, a closure letter. It's actually an order, a site rehabilitation completion order, in less than 2 years from the date we acquired the site. And we also closed out their long-term groundwater monitoring obligation. For those who are following what's going on here in the City of Stuart, the city also has long-term groundwater monitoring obligations that started back in 2000. We took that obligation over for the City of Coral Springs. We completed that obligation successfully, and this letter is evidence of that. Once we completed the cleanup and the regulatory obligations, we moved quickly to reuse. We have at least a half a dozen offers to redevelop that landfill site, just like we think we're going to get with the City of Stuart site if the commission deems it appropriate to approve the resolution. We have at least a half a dozen industrial developers who want to build between 200 and 250,000 square feet of industrial on this former landfill site that's been hiding in plain sight for decades. These are just two of the site plans submitted by different developers. There are other reuse options that we're considering, including logistics-related fleet parking. That's also a very viable end use. The second site that I want to talk about that is very similar to the city site in terms of its DNA, its environmental DNA, its regulatory DNA, and its redevelopment capacity DNA, is a site that we acquired in the city of West Palm Beach. Like this city's site, that site was also owned by the city of West Palm Beach. It was owned by a municipality. It was first developed in the 1920s when the city of West Palm Beach and Palm Beach County, town of Palm Beach rather, put two incinerators on that site, a 20-ton incinerator and a 40-ton incinerator. And they ran that incinerator for about 30 years and buried the incinerator ash on that site. In the 1940s, the airport, by the way, our site is right here, another hiding in plain sight site. This is I-95, this is Belvedere Road, this is the exit, this is Palm Beach International Airport, and here is the literal front porch to the airport. This is the surficial roadway that gets you into the airport. In the 1940s, Palm Beach International Airport was Morrison Naval Airfield. The Department of Defense took it over. They started utilizing that landfill, and rumor had it that there was unexploded military ordnance as well as medical waste. We acquired that site through an affiliated entity called the Goldstein Brownfields Group. We were convinced that we could accept the environmental risk. We did. We found a lot of medical waste. We didn't find any unexploded ordnance. Like the City of Coral Springs site, we quickly entered into a series of cleanup agreements with the Florida Department of Environmental Protection to memorialize legally our commitment to conduct the cleanup consistent with applicable law. We entered into, again, a brownfield site rehabilitation agreement. We negotiated a waste relocation and soil management plan. That's the document whereby DEP makes sure that you engage in the choreography of digging up solid waste and digging up dirty soil, and doing so that's fully protective of human health and the environment. You're required to document wherever you move dirty soil. You're required to monitor the air. You're required to have a health and safety plan in place. And then finally, we entered into a cleanup plan, a remedial action plan, which we implemented in short order. These next photos show what we did on the site physically to smooth out over 100,000 cubic yards of incinerator ash, construction and demolition debris, and medical waste to make the site ready for redevelopment. And this is just some of the photo documentation of those activities that occurred over a one-year period. EPA finally was so impressed with us when they approved our completion report. They sent us a letter that said, forgive me, my eyes fail me, thank you for your outstanding cooperation in the remediation of the site. That goes to show what kind of partner we are with the regulatory agencies. We make representations, we live up to those representations. And then finally, in terms of reuse, what was a fallow site with waste 25 feet above ground and 15 feet below ground ultimately was graded and cleaned up. We started with a Wawa on the corner. This is a side view with a Wawa, and you can see the self-storage facility in the back. Another elevation showing the self-storage facility, and then over here we've got a massive dealership. And this shows the dealership as well along Australian Avenue, where for over 6 decades there was nothing but uncertainty and access to an uncontrolled waste site. We worked quickly with DEP. We cleaned the site up. The redevelopment capital spent on this site approached $100 million and has created hundreds of jobs and, of course, added millions of dollars to the local tax revenues. The final site I want to talk about is similar to the Stuart site, not so much in that it was a landfill site. It wasn't. This site had a significant release of chlorinated solvents from the storage of those types of chemicals in connection with a janitorial business. It's similar to the city site because the Stuart Landfill also has a chlorinated solvent problem that has been subject to remediation and monitoring for almost 20 years now. Like the other two sites, this is a site that is located in a very densely populated portion of Miami. This happens to be an environmental justice neighborhood. It's one of the oldest African-American neighborhoods in the state of Florida, or I'm sorry, in the city of Miami, subject to tremendous disinvestment. We acquired the site. We entered into a cleanup agreement with the Florida Department of Environmental Protection. We actually applied for a grant to the US EPA and DEP for cleanup, which was approved. That's this letter here. These pictures show some of the cleanup activities that occurred. We not only excavated soil, we stuck holes, we drilled holes throughout the entire site and off-site and injected certain proteins and, believe it or not, vegetable oil in a proprietary mix of what are called amendments as a way to clean up the chlorinated solvents. When we started testing for the extent of contamination back in February, This is a representation of the extent of the plume in one of the intervals. My eyes are failing me, so I can't see whether that's shallow or deep. But we started with this extent of the contamination. This is off-site in February. And then in July, after all of our remediation, you might see a little green circle here. That's all that's left. We destroyed about 99% of the contamination at that level of the aquifer. In the interest of time, I'm going to skip over some of these slides. These slides discuss the specifics of our remediation, a short-term remediation event and then a long-term remediation event. Here's the reuse. Keep in mind, this was a site in an environmental justice community subject to tremendous disinvestment that no one wanted to touch because of the environmental risk. We acquired it, we cleaned it up. We now have a contract with the 7th largest apartment portfolio owner in the state of Florida. They are going to build 612 attainable units and 2 20-story buildings with almost 10,000 square feet of retail. It's a $140 million investment in this property where there had been none for over 30 years. Okay, I want to turn now and talk a little bit about the city site and the environmental situation at the city site.
Excuse me, Mr. Goldstein.
Yes, ma'am.
Mr. Kite, if you'd like to sit down until your turn.
all day, man. Thank you.
Oh, okay, all right.
So many of you may know this, but for the benefit of the public that doesn't, the site we're talking about is referred to as the Old Stuart Landfill. It was initially used by Martin County, and then it was conveyed to the city in 1962. The site was used to dispose of municipal wastes essentially from 1950 to 1980, but it continued to accept wastewater sludge until 1987. That comes into play in a few moments. The site is approximately 62 acres. I believe we're taking approximately 50 pursuant to the purchase and sale agreement. We have solid wastes and sludges from the city's wastewater treatment plant and commercial, residential, and industrial wastes in the landfill. At least that's what we know to date. And then the types of chemicals we see are those that are not inconsistent with the chemicals that we've dealt with at the 3 projects that I just mentioned, including chlorinated solvents, petroleum hydrocarbons, and various metals, including arsenic. There's also not an insignificant amount of medical waste at this site, which was reflected in some of the city's documents. And again, that's something that we have experience with, which I demonstrated at our West Palm Beach site, which was a very successful redevelopment project. The city also, similar to some of our other sites we talked about, has entered into not 1 consent decree with DEP, but 2 consent decrees. The first one was in 1980, the second one was in 1991, and actually the second one was amended in 1997. In 2020, DEP wrote to the city and said, in addition to all of this other stuff that you guys are doing, and thank you for doing it, we've discovered that the city has another problem, which the commissioners may or may not be aware of, and that's PFAS, okay? This is not to be unexpected because, and I'll fast forward to the end of the story, there's PFAS everywhere in the state of Florida. Everywhere there's a fire training center or a fire station or an airport with a fire component, you've got PFAS. Anywhere there's a landfill, you could potentially have PFAS because not only is it ubiquitous in all kinds of human household products, there's a significant level of uptake in our bloodstreams from ubiquitous exposure to all of these PFAS-containing materials. And so the materials get excreted out in our wastes and collected in wastewater treatment system biosolids. We have a lot of wastewater treatment sludge at the landfill. I promised you I would tie the 2 together. So that's an issue that we know we're going to be responsible for going forward when we acquire the landfill, if we do, if the commission deems it appropriate, That's a cost and a challenge we are willing to take on. This is a page from DEP's report issued in, what's the date on that? I can't see that far. That's 2019 or 2020. 2021, a very recent report that DEP issued and sent to the city, along with a letter saying, you guys are responsible for the PFAS up here at the fire training center. I think it's up here. Again, I can't see that far. The standard, the cleanup standard in groundwater is 70 parts per trillion. At the fire training center, you have it at over 33,000 parts per trillion. It's a huge number. At the landfill, we have it at, I say we because we feel very proprietary about it already, we have it in the hundreds of parts per trillion, and the state seems to believe that this is a separate source. So when we acquire the landfill, we'll be responsible for cleaning up the PFAS, okay? The cost of cleanup is just, and I'm concluding shortly, I appreciate you bearing with me. It's an important opportunity, and we wanted to demonstrate our seriousness of purpose by giving you a very detailed presentation and trying to anticipate your questions and concerns. The cost of cleanup cannot be calculated at this point. There isn't enough data to do that. We're going to spend likely hundreds of thousands of dollars, again, if you deem it appropriate to go to contract with us, to investigate the scope of all of these issues and come up with very precise cleanup costs. And of course, all of that data will be the city's, so that if we don't close, you'll have the benefit of all of the effort that we've gone to at our expense. Separate and apart from the cost of cleanup, and this is what I want the commission to focus on because I know there's some concern about the grand price that we're paying for this asset. And I respectfully suggest that the commission should look past the grand price of what we're paying for this asset, spoiler alert, it's $100, to what we will be spending to bring this site back into productive reuse because it's a landfill. There are certain conventional development costs that get incurred at any development site. We're not talking about those today because it's not proper. What we're focusing on are the incremental costs, the distinct costs, the particular costs that only apply to a landfill. And that, to us, is the value, the real consideration that the city is getting from us as a result of our proposal. This is money that the city doesn't have to spend because we're going to spend it and our development partners are going to spend it. So let's talk about what some of those costs are generically and how they may look at this site specifically, okay? Keep in mind that these are back-of-the-envelope estimates because we're not in contract. We haven't spent $1 yet on doing our own proprietary tests and filling in the gaps that exist that would allow us to be more precise about actual costs. Having said that, when you build on a landfill, you can't build on a landfill the way that you would on a regular site. On a regular site, you've got a nice, flat piece of property that is generally stable. When you build on a landfill, it's like the property is drunk. It's listing from side to side, and if you put a flat slab on a landfill, what's going to happen? It's going to settle differentially, and the slab's going to crack, the building's going to fall down, it's going to be a disaster. So typically what you do is you either dynamically compact the site, where you drop a heavy ball on the site over and over and over and over again until all of the waste has been smushed or consolidated, or you turn it into a dock. Literally, you build on piers. For a site like this, my guess, we haven't engaged these wonderful consultants I mentioned at the top of the presentation, Kimley Horn and Langen and Geosyntec, who have done hundreds of these. My guess is that we are going to be building on piers on this site. It's 50 acres of solid waste down to 15 feet, maybe more. That adds $15 to $30 per square foot that you don't have to spend on a site that doesn't have landfill conditions. That's not the city's cost. That's Goldstein Kite environmental cost, okay? And sometimes you can get away with just doing the pounding of the site to compact it. Sometimes you have to do both. And that's a good rough estimate for a unit rate for dynamic compaction. It should be $1 to $2 per square foot. On top of that, if you're going to build on solid waste that has an organic component like this landfill does, where you have trees and yard waste, what happens when you bury organic waste? It decomposes. It generates methane. You can't put a structure on top of a site that generates methane without building a barrier to prevent the methane from getting inside the building, because if you do, the building blows up. This is a common landfill practice for dealing with the risk associated with methane, and it adds $2 to $5 a square foot. What does that mean for this site? We did a back of the envelope analysis that Mike helped us with from a land planning perspective. We've got a 50-acre site. We take out our setbacks, our retention, et cetera. We think we'll end up with 35 to 40% for building coverage. That gives us between 763,000 and 871,000 square feet. When you multiply those costs that I just mentioned, you end up with incremental costs of between $11.5 million on the low end, $26 million on the high end. That's to build on pilings. You've got $763,000 on the low end and $1.7 million on the high end to dynamically compact this site and to prevent the buildings from blowing up by constructing methane barriers between $1.5 million on the low end and $5.2 million on the high end. Again, these are things that are a bare minimum necessary to bring this site back into productive reuse that are only necessary because it's a landfill. That's our cost. That's not the city's cost. That's our true purchase price. Finally, the city engaged its own consultant to look at reuse. At one point in time, the city was looking at, not that long ago, 2019, redeveloping 8 acres of the 50-acre site. So the city hired this firm to come up with an analysis of the permitting issues, the development issues, the incremental cost issues. And what they found is that for 8 acres, the incremental cost could range up to $5 million. I've got the various elements for waste relocation on site, dynamic compaction, and waste removal. What we did is we used the city's own consultant, the city's consultant's analysis and unit rates to extrapolate a cost over 50 acres. And what we came up with was $8.4 million on the low end and $14 million and change on the high end. So even if you don't believe our numbers, 11 to 26, 763 to 1.7, and 1.5 to 5.7, looking at the city's consultant's analysis extrapolated over 50 acres, there's still a major premium that someone has to pay. That's the true purchase price. That's what the city saves, because we're spending that money. The city's not spending that money. I want to go through some key environmental provisions in the contract briefly, because I know there's some concern about what the city's agreeing to. The first thing I want to point out is that we are releasing the city from all environmental costs, responsibilities, claims. Once we close on this site, there is no way that we're going to come back, or can we come back legally to sue the city or to try and recover any of our costs. All of this is on us. This is what we do for a living. We have a high level of tolerance for this environmental risk and the ability to underwrite it. If we close, we're not coming back to the city looking to have the city write us a check. In addition, there's no indemnification. The city is not indemnifying us for any of our costs. If we get sued, that's on us. It's our responsibility to defend that lawsuit. So it's a complete environmental release. There's no environmental indemnification whatsoever. Moreover, by contract as well as by law, we are going to be required to clean this site up to the applicable standards allowable under state law, which is exactly what the city is doing now. The city is subject to cleanup obligations under state law because it owns the landfill, and the city is using what's called risk-based corrective action to take advantage of cleanup standards that are appropriate for the particular land use. That is classic environmental redevelopment. It is an efficient way to proceed, and it conserves dollars that would otherwise be spent needlessly over addressing an environmental risk. I'm going to cut to the quick a little bit. There's one last provision I want to talk about here, and that's this. We have language that requires cooperation by the city in the application for grants. There is one grant in particular that we're focused on. It's part of our ethic under Goldstein Kind Environmental and our commitment to environmental justice. There is a grant window that closes very shortly. It's October 5th for workforce training. Okay, and I have some language here that talks about the grant and the purpose of the grant relative to workforce training. Essentially, these are gateway financial opportunities to bring the unemployed and the underemployed in a municipality into the new green economy. It requires the application by either a 501c3 not-for-profit or the local government. Best case scenario, it's a coalition of both. We have an affiliated not-for-profit called the Goldstein Brownfields Foundation that I started in 2008. We've long been dedicated to supporting environmental justice communities and advocates. We think not only is this site a great site for redevelopment, but it's a great springboard for other related sustainability initiatives and equity initiatives, including environmental justice, through workforce training. We are ready to swing into action and do all of the paperwork necessary to apply for this workforce training grant and bring in at least $200,000 in federal funding to, again, allow the unemployed and the underemployed access to the new green economy through the redevelopment here. And as an aside, what I'll say, I need to add to our commitment by noting that whatever vertical developer we bring as a partner here, there are going to be clearly stated expectations memorialized in writing that speak to hiring from the local workforce, from using local contractors. At GKE, not only do we look for opportunities to apply for federal and state grants, which we've done successfully, and to encourage and require our contractors to support local workforce and local contractors, but we take a percentage of our upside, and through the foundation, we look to further invest in EJ stakeholders. It's what environmental redevelopment is all about at the state and federal level. Environmental insurance. At the top of the presentation, I mentioned we're focused not only on limiting our exposure to liability, but the city's exposure to liability. We've covenanted to procure environmental insurance here and to use our best efforts to get the city on our same policy and get them the same amount of coverage that we are getting for ourselves. Environmental insurance, as you can see on this slide, is recognized at the federal level by US EPA as an effective tool to bring impacted sites back into productive reuse and protect capital. We work, again, with Highland, with whom we feel is one of the best environmental insurance agents in the country. The highest rated insurance providers in the country are providing environmental insurance and have been for decades. Finally, we're on the glide path now. As we go forward and redevelop this site, we are very in tune and familiar with all of the guidance that exists at the state and federal level to build on old landfill sites. The state of Florida has its own webpage for beneficial reuse of old landfills and a guidance document that was recently updated in 2019 that we're very familiar with. This document on the right-hand side is a federal guidance document that talks about building on landfills in a way to mitigate against the vapor intrusion risk and prevent buildings from blowing up. This is a federal document that comes out of the Superfund program. Our site is not a Superfund site. These are a series of case studies that talk about the ways in which you can successfully build on and reuse capped sites, which is what this site will ultimately be. We're focused on stormwater as part of pollution prevention going forward, and there are very specific protocols at the federal and state level for designing stormwater infiltration on environmentally impaired sites. We follow all of the state and federal guidance. This is a draft guidance document at the state level that came out about a year ago. In meeting with the, you commissioners, at least with one commissioner, I talked about the opportunity to incorporate urban farming at this site as part of reuse, which is very much a best brownfields redevelopment practice. Renewable energy on capped landfill sites is an exciting opportunity for us in terms of reuse. It's a secondary option we're looking at, but one that we are going to take seriously. The federal government, EPA in particular, and the Department of Energy are heavily invested in bringing impaired sites back into productive reuse through the production of renewable energy. And then finally, I want to emphasize this again. I mentioned it a few times. We are focused not just on the four corners of the property, on living up to the bargain that we make with the city in ensuring that environmental health protection is addressed and that any exposure to sensitive receptors, adults, children, occupants, longtime employees is mitigated. We're concerned about transparency. We're concerned about opportunities for the greater community to participate in the financial upside. These notions of stakeholder involvement and engagement are part and parcel of our ethic in environmental redevelopment. It's a culture that I was brought up in and helped promote starting 30 years ago in the state of Florida. These documents that I've included, just for reference, speak to the best management practices in this regard. Brownfield Stakeholder Forum Kit, and then finally we've got lots of good strategies to work with the federal government and the state of Florida to limit the city's exposure to liability as well as ours. That is our presentation. You've been very patient with me. Thank you for this opportunity.
Madam Mayor?
Thank you, Mr. Goldstein. Mr. McDonald, Commissioner McDonald?
Yeah, hey, first of all, I love the idea of this, so I think that we're off to a great start. So, but I do have just a couple comments and a couple questions. One, I love the idea that trying to work in the green economy and the workforce development. Spent a lot of time working at that through our business development board, so I think that's exciting. But just my question's more on a couple contractual issues. One, and I'll just take the easy one, because it's just more of a comment. It'd be great if you guys paid title, but I'm going to get to the environmental addendum. And I guess my only concern, well, maybe not my only concern, my concern of real concern is I'm actually pretty satisfied that once you guys close, you guys sounds like you do a pretty good job. You've talked about a lot of successes. Have you had any failures?
I haven't been sued yet in 30 years as an environmental lawyer.
Okay, that's
On the redevelopment side, we haven't stumbled because we pick very, very carefully.
okay.
We're very careful in how we identify opportunities, pursue opportunities, and the diligence that we conduct.
Okay, so run me through the process a little bit. So you're going to start your feasibility study in your 275-day due diligence period. When you do that, you're going to do boring samples, maybe dig a couple holes, something like that, I'm guessing. And you're going to have engineers doing studies, looking compaction tests, I'm guessing all of those type of things. When is it that you apply to the Florida Department of Environmental Protection for the remedial action plan? Is it after your feasibility study and after you close?
Okay, so that's a very good question. I'll try and be brief. You're really touching on one of my favorite subjects, and as you know, I can go on and on. The work that we do during due diligence, the phase 1 investigation, which is non-invasive, and the phase 2, which is invasive, you were just talking about what that might look like in part. The soil borings, the soils test for geotechnical purposes, the groundwater testing. That's a due diligence transactional-based process. When a party closes on property and takes ownership of contaminated land, the rules change. And a very exacting standard and process kicks in under state law that requires a different type of phase 2 investigation. It's called site assessment. The phase 2 investigation is thumb to the wind, does this feel right? Do we have a sense for what's going on? When you buy the property and you engage in formal cleanup with the regulators, which you don't do until you have ownership, then you lose control of the process. The state controls the process. There are certain endpoints that you have to get to in order for the state to say, we agree that you understand the contamination here, how widespread it is, and how deep it is. Once that process is done, and Commissioner, here's why I answer your question, we are then approved to prepare a cleanup plan, like we've done several
And that's
times, as I
after-
demonstrated.
But that's not until after you close.
Yes, sir.
See, here's, what what I'm concerned about is that during your, I guess your phase 2, your evasive portion of your feasibility study, that we open up a can of worms, you look at this and go, you know what, this is really bad. But because you've opened it up and started, now all of a sudden, we have to move forward with a very expensive cleanup, and you're gone because pursuant to the contract, your liability is gone, and we're stuck with a big, having to do scramble to how to, so I just want to.
Let's talk about that.
What, pardon?
I said, let's talk about that.
Yeah,
a
that's
great
what I'm looking
insight.
for. I want to get some just assurances
Sure.
to get me to feel good.
That's a great insight and a smart observation. Unfortunately, it's the nature of selling a piece of property, right? No buyer, no sophisticated buyer, especially for an asset like this, is going to close with one eye open, right? It's important that any buyer, especially a buyer like us, who is going to knowingly accept all of this cost and risk, have an understanding for what they're dealing with. I say this respectfully, not provocatively, not respectfully. I mean, respectfully, not provocatively. The city already has absolute liability for whatever environmental conditions exist at this site. There have been 20 years worth, there has been 20 years worth of monitoring here of the non-PFAS issues, and by and large, that's gone spectacularly well. In fact, the correspondence that I've seen, recent correspondence in the DEP file, indicates that that cleanup may be coming to a conclusion. Unfortunately, we've got this PFAS issue.
We're actually very familiar with the PFAS
Okay.
situation. So.
Which the city can't avoid, right? So there's nothing that I expect to find here that we're not already aware of. It's a matter of filling in for us the data gaps to understand the extent of the problem so that we can better underwrite the cost. I've looked at a lot of landfills in my life. This is a very conventional municipal solid waste landfill.
And so back to, I guess, my original question, the application for the remedial action plan is actually after you close.
It is.
Okay, so that's when you start the state process.
That is correct.
Okay. Hold on, I got a couple. Just want to make sure I'm catching all of my notes here. Brownfield. And so then once you start that remedial action plan, that's when I guess you go and enter in with the state, the Brownfield site rehabilitation agreement and the
Yes, sir.
And the site rehab completion order with conditions.
So the site rehabilitation completion order, many commissioners may have heard the term generic term called an NFA letter,
Okay.
a no further action letter. That's, Commissioner, what you're referring to. It's actually an order. It's not a letter, it's an order. And in the state of Florida, they use a specific term called a site rehabilitation completion order. That comes at the end of the process. You conduct the assessment, you submit the remedial action plan, you implement the remedial action plan, and when you meet all of the endpoints for cleanup, then you get to apply for this closure order.
Okay, and then while you're doing your feasibility study for the cleanup, are you going to be doing your site planning review, or feasibility as far as what your use is going to be for the?
Absolutely,
Okay.
100%.
And will you be going through full site plan review during your due diligence
I
period?
don't know that we'll be going through full site plan review, but we will be working very closely with your excellent professional staff the city manager, the development director, the city attorney. Commissioner, let me throw this out here. We are certainly willing to agree that we will not submit any of our data to the Department of Environmental Protection without the city's consent. And furthermore, we're willing to pay for a third-party review of our data by an environmental consultant. In other words, the city can hire whatever consultant they want to review our report. We'll pay for it. Just send us a check, or we can put
Send
money
you a bill, not a check.
What's that?
I'm glad you caught that
You
one.
could send us a check too. You know, whatever makes the city happy.
I always know which way the checks are going.
Because I'm a lawyer, I'm used to paying money in retainer or receiving money in retainer.
I'm married to a lawyer.
Okay. So we're happy to write a check to the city for 2 or 3 or 4 times whatever the estimate is from the city's consultant to provide oversight, so that they have an independent voice, so that you have an independent voice in your ear about the significance of our findings and whether it creates undue stress in terms of our sitting down and discussing those findings with the state. We want to get to the closing table with the city. We think it's a great property, we think we're a great team, and we want to address your concerns. This may be a way to address that concern.
Yeah, that's actually very useful. And then and then far as the remediation, so is there different levels? I can't remember. It's been a while since we spoke in person. Is there different levels of remediation?
Let's talk about that. So Florida has one level of cleanup standards for groundwater. That level is not based on use. There's a single standard for various types of contaminants in groundwater. For example, for arsenic, that standard is 10 parts per billion. And that's true whether you're putting a daycare or a park or a warehouse. For soil, it's very different. There are standards based on residential. There are standards based on non-residential, which include commercial and industrial. For example, the standard for arsenic for soil is 2.1 parts per million. For industrial and commercial, it's 12 parts per million. Okay, so there's a distinction there. The distinction is deemed acceptable by the U.S. Environmental Protection Agency and the Florida Department of Environmental Protection and the Florida legislature, because the science demonstrates that given those uses, the various standards in soil have the same level of exposure to unwanted health impacts.
Yeah, because the last thing I want to see is, or have a concern about, like a cancer cluster. My father grew up, worked in the utility business, and and PCBs were a big problem, and
Right.
and especially up in Ohio where we were at, there were places that it was dumped all over the place, and there was a lot of concerns. I don't know what's in this landfill. Sounds like PFOS for amongst other things, but.
And chlorinated solvents and benzene, all of which are carcinogenic, and all of which at one point were in the groundwater and impacting the city's drinking water well field. But the city responded to those threats decisively and effectively, and we intend to do the same thing with strict oversight from the Florida Department of Environmental Protection.
Okay, so, and you mentioned oversight. So your oversight will come from the Florida Department of Environmental Protection, the EPA, and then of course us.
Yes.
So, because I think that's going to be one of the things that is going to be of concern to the community, is that we are actually, we're making sure that you'll be following all of the procedures. It sounds like you have a great track record, so I'm not so concerned about it. But nowadays we got to make sure that the public is very involved in these environmental issues, and we need to really make sure that that we're showing that we're covering those.
So let's talk about that. I mentioned briefly, I know you're probably getting tired of me. I mentioned earlier that we are committed as part of our ethic, as part of our mandate to community engagement and transparency. There is a built-in community engagement component in the Florida Brownfields program that requires any party executing a brownfield site rehabilitation agreement, which confers certain benefits, to create what's called an advisory committee and to hold public meetings as the cleanup progresses, from site assessment through remediation planning, through remediation implementation. That is a regulatory mechanism that we will be legally obligated to comply with, but that's a bare minimum. We go way above and beyond that by complying with, pardon me, Kelly, the various best management practices that these types of documents provide for. Hold on, there's one here I want to, there we go. This one. Stakeholder equity. The building block of stakeholder equity is transparency and community engagement. And we have some very unique and innovative ways to ensure that the public is engaged and informed of everything that we're doing from a cleanup planning and implementation perspective every step of the way.
Okay, thank you very much. I appreciate your responses. Thank you.
Thank you. Mr. Meyer?
Okay, well, I really appreciate the thoroughness of your presentation. For wonks, we love knowing that you know what you're doing. So I wanted to follow up on one of Commissioner McDonald's questions, because that was sort of where I was going. You obviously are experienced in this, you have a track record, you're very targeted in your approach. What I was hoping for when he said, do you have any track records of failure, it's not, you know, have you been sued or whatever. So you're looking at this property. Are there any other examples of properties that you have, you know, entered an agreement on and then backed out of after your phase 1, phase 2 assessment?
As a developer, no. As a development partner, no. We've represented, keep in mind, I've been representing clients for 30 years. We've represented hundreds and hundreds and hundreds of clients who have done thousands of deals. So we've represented clients that have pulled out of purchase and sale agreements for sure, when the risk-reward ratio was not in a correct proportion. It can happen.
Right. So I guess where I'm at is, you know, with all due respect, what we're hearing is that there's this incredible amount of risk. We have this giant albatross, and yet you've also said that the City of Stuart has been doing such a great job over the last so many years, complying with the DEP, managing cleanup targets. We're nearly done with most of the standard contaminants. Obviously, Pfas, PFOA is a huge issue. I happen to be working with the Florida League of Cities on looking forward at, you know, federal addressing it through federal action. So in my view, you brought up the map of all of the communities in Florida that are dealing with PFAS. Every landfill in Florida has a PFAS contamination issue. Every public safety complex, every airport has a PFAS issue. Yes. So I want to calm everybody down a little bit. We are not the only community in the entire world that, like, we better do something right now. And that's not because PFAS is not an issue. Everyone's dealing with it, and it's not, I don't believe that it's on all of us, because we have been passive receivers of PFAS. We are not Dow DuPont. We didn't make it. We didn't know that it was bad. And so there will be federal and state action to help address PFAS, indemnification for local governments, resources to assist with cleanup. Currently, our problem has been, we've been trying to clean up some of our soils around our public safety complex, and we haven't been able to find a partner that is willing to dispose of it. So I'm curious.
I can help you.
Okay, yeah. So clearly, you have a way in.
We'll
How are you
that in.
currently managing contamination in soils for PFAS?
Well, that's a good question. Because this risk is so new and the science still developing,
right,
there aren't a lot of efficient approaches. There's destruction, and then there's off-site disposal, at significant cost.
So we were looking at trying to ship our soils off to Texas?
It was the spent resin cartridges that had actually removed
Right.
the PFAS and
In the
PFOA from the
plume
water.
from the water, right.
That was originally going to the place in Texas, and the federal DEP, I believe, said that when you burned it in Texas, that it would then be in the air, and because it's a forever chemical, they've altered the modification of that issue.
So, okay, I guess, I've got a couple questions I'm going to fire out. I also have kind of comments for my colleagues up here. This is a liability. I agree. It's a liability. I would love to see us do something about it. I don't think that because of, the standard waste issues there, PFAS aside, we have been doing a great job at considerable expense over time. I just looked in our budget again. We have about $50,000 budgeted this year for landfill, in our landfill portion of the fund. So we've been spending money to do our part the best we can. 50 acres in our urban core of land that cannot be built residential currently. DEP, in its own documents that you've said there is not, I know you're proposing potentially an industrial use or commercial use. Residential's out of the question. So we're looking at a development, a structure that could be, a good addition to the tax base, but industrial or commercial. Could we benefit from that? Absolutely. However, we're looking at a site that currently it's difficult to build on. There's going to be significant grant funding through Brownfields programs. I know you're taking on some risk, would be taking on some risk, but the taxpayers ultimately are going to be paying for this remediation through those grants, and then we'll have this property that will be built on when the DEP's own documents say that they prefer alternative uses for old landfill sites, like, I hate to say it, parks, ball fields. The department prefers ballparks, soccer fields, hiking trails, golf courses, golf driving ranges, prefers these to be selected for an old site rather than construction of structures. So I think this is an opportunity. It's a potentially great opportunity. I will be honest, the $100 is a slap in the face to me. I understand that it comes from the fact that there's risk, but also you clearly know what you're doing. You have a great track record. You have all these partners, and there's a lot. You helped develop the Brownfields program. You know that there's funding lined up. I think that I just don't think it's appropriate for us to be giving it away when we've done such a good job over time managing it to our best ability, and it could potentially be used in different ways, even though it is still a liability in some sense. I don't know if I'm making sense. Maybe I
Commissioner?
should just stop.
Commissioner, can I respond quickly? Because it was certainly not intended as a slap in the face. That was
I know it wasn't.
That was a number that we negotiated over a period of 2 years with your excellent professional staff, and they understood clearly maybe I didn't do a good enough job articulating the value proposition here. The money to clean up and redevelop the site has to come from somewhere.
Right.
You cannot afford to pay market rate for this site because there are too many extraordinary things that have to be done and costs to be incurred as a result of its landfill status. So the normal economic equities that would apply to a buy-sell agreement don't apply here. It's not, and I don't want to say it's an incorrect statement, but it's not a complete picture to represent that the costs of remediation will be picked up by grants and that the taxpayers will pay for the grants. The availability of grants here is very limited relative to the cost of cleanup. The cost of cleanup here is likely to be $5 to $10 million if it's a penny at the end of the day as you activate this site for redevelopment. That's one side of the ledger. The other side of the ledger is the incremental cost to build on this site. If it's in the Commission's wisdom to allow this site to be redeveloped for commercial purposes, whatever that means, then someone is going to spend a lot of money on this site, preparing the site for suitable uses using the methodologies we discussed and that your own consultant identified, okay? That has to come from somewhere, and those costs aren't eligible for grants. That's private sector money. This is not a deal where we're buying a corner site from the city and we're going to spend $10,000 or $15,000 on due diligence. We're looking at spending hundreds of thousands of dollars before we go hard, and then tens of millions of dollars to clean up and redevelop the site. This is not money that's going to be borne by the taxpayers. In the largest part, it's not going to be eligible for tax credits or for grants. In terms of grants, I mentioned that workforce training grant in particular because it's got such a short window of opportunity. And we're ready to apply our resources to bring all of that opportunity in the city. That may be considered a rounding error in light of the other priorities that you may have, Commissioner, and that this commission may have. Let me say this. If the commission wants to return this site to productive reuse, wants hundreds of millions of dollars invested in the community, wants thousands of jobs created, wants to abate a human health risk on an accelerated basis, we're your team. That's a legitimate policy choice. On the other hand, it's also a legitimate policy choice to say 50 acres, public park. It's a great opportunity for a public park. And I'm not here to twist your arm from a policy perspective, even though I love talking about policy, and it's what I do every day when I wear some of my other hats. The cost, though, of checking that policy box, reserving the site to the city for public use, that's going to have a very significant cost, well beyond the $50,000 I respectfully suggest budgeted this year. This will result in the city looking for many, 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 many millions of dollars to make that site safe for park reuse. And then, of course, you're not going to have the tax revenues or the job creation. Again, policy choice. If you want to bring it back into productive reuse and do all those other wonderful things that attend to a beneficial reuse, we're your team. I think we have a good offer and a fair offer, not intended as a slap. We think it makes sense economically for all sides, which is how these deals have to work, especially when they've got environmental risk. We negotiated it at length over a period of 2 years with staff. I believe in the agenda, staff recommends moving or approving the resolution. We hope you'll agree and vote in favor of the resolution.
Madam Mayor?
Thank you, Commissioner McDonald.
Mike, I think that, one,
Is
it
that,
was
is
actually a
that Mike
park.
Meyer, the Commissioner Mike Mortel?
No, Mike Meyer, I'm sorry, Commissioner Meyer. Anyways, it was actually a park, I don't know if you knew that one, it was actually not a park, it was a driving range that did not, well, I think then also, in addition to the, I guess, 2019 that he talked about, where the city looked at doing it as a facility for the city, we looked at that was a joint facility with the county in 2013, 2014, somewhere in that area, and the cost was
Sure.
prohibitive. I certainly understand it. I would personally, I'd love to have a 50-acre park with bike trails and stuff because that'd be great. I just don't think that. I think if I'm still getting where I need to be. I think I'm still worried about the liability, but at the same time, I think that the potential gain from both the tax base and jobs, I think is an incredible possibility that many years when none of us are sitting here, people will be very grateful.
I agree. I mean, we've met, and I'm all about infill.
Yeah.
This is a case for infill for sure. But this is not, for me, this is not your normal infill. This is a distressed asset. And I guess I'm quoting from the DEP brief on preferring parks and soccer fields and hiking trails. Obviously, if we were to try to put it into a public use like a park, yes, we would need to make sure that we covered the cost of the cleanup so that kids running around didn't trip and fall on a needle. But an alternative, and I know this is a little crazy, but just want to throw it out there. There's a lot of emerging research on afforestation efforts for old landfill sites that both clean up and create green space in otherwise difficult or unbuildable properties. So, I mean, well, it probably won't take care of the PFAS, but there are examples of old closed dumps, landfills that have been turned into mini forests. And so, I mean, that's just one potential use, or maybe it could be incorporated into a final redesign.
Commissioner,
This is a.
what if we agree to carve out a portion of the property and work with the city to take 5 acres or so and create a public park?
I mean, that sounds like a nice addition. Okay, so there's that. The other issue, the logistical issue with redevelopment. We've had a lot of approvals in this area in the last couple years. Traffic is an issue. And so if there's an industrial use here, I know we had talked about potentially this being a last mile logistics site, which I think is a good idea. The constraints on Monterey make it so that connectivity, I think, needs to be addressed. The southern side of the property, backing up against Astor and all those other roadways back there in that neighborhood, would be, I don't know how we would address that, if that would be a FDOT issue or.
If you're talking about a connection for the
Yeah.
road, I mean, it would be potentially I think the church owns the last segment that would be required to get across it, but it would be not FDOT, it would be us.
It would be us.
Yeah.
We currently have an agreement with the church to allow us to have public safety access through that roadway, so it would have to be expanded to turn into.
Okay.
Out of respect for
She
Commissioner
missed the-
Bruner. Hold on,
couldn't hear.
Mr. Mortel or Mr. Dias, could you just summarize your response to Commissioner Meyer, please?
He was just saying he was talking about the access through is that what's the name of the road?
Astor?
Astor Lane, sorry. And
Yeah,
that-
it rounds up, I don't know if we can zoom to it really fast, but it really just gets right along the southern tip of that property, that little curve before the church. The church is to the west.
So that piece is owned by the church.
Okay.
And so the church, we currently have an agreement with the church to allow us to have public safety access vehicles through there, but not anything for general. They may be willing to do that, but not at this point.
Okay, well, I mean, I'm getting cart before the horse, but
And
I
I
mean,
was going to say
obviously,
that's also a more of a zoning.
it's a
or
zoning and site
development
plan
issue.
thing, but again, it's just, redevelopment, especially at something at this scale, there's other considerations that we would need to think about.
All right, are you still chomping at the bits, Commissioner McDonald, or did you?
No, I'm good.
Okay, Commissioner Vice Mayor Matheson.
Okay. Well, we've answered actually quite a few questions. In my mind, I keep coming back to the one issue that perhaps it's on me or all of us, but I don't know enough about brownfield remediation, and I don't know that I'm confident I'm going to learn it here today. And I keep thinking about that. It's an unsolicited offer. I need to learn more. Some of the things you've mentioned in your presentations stick out to me. One of them, which is great news, is that the city's doing really well, as Commissioner Meyer pointed out. You said the site would be cleaned up to applicable standards under the law. And then, I'm quoting you, you said, which is exactly what the city is doing now. And then a little later in your presentation, and the city is doing a great job of it.
Near as I can tell by reviewing the publicly available files.
So for me, in my position, that tells me I don't need to rush, because I want more knowledge. I'm not as concerned, and I agree with you on the monetary issue. I'm not going to sit up here and argue for $110 over your $100 offer. I'm more concerned with the guarantee and the level of cleanup. You know, that's my issue, is I don't know enough about it. But, I mean, let's just take dynamic compaction, as you described. When I think about that, you take a giant heavy ball or compacting device and smash the contaminated soil with it. It'd be like me taking a sponge soaked in the same contaminants and smashing it down on the counter. All that liquid is going to go out. It's going to go somewhere. So can you break that down for me?
Sure. The parallel is not exact.
Okay.
It's not exact. And as a practical matter, these types of sites, and I in my brief presentation, it could have been longer, we looked at 2 landfill sites where those types of construction methodologies were applied. DEP in the state of Florida, EPA all over the country, they deal with redevelopment and remediation on landfills and impacted sites every single day. And there are not only methodologies, but accountability protocols that are implemented in terms of groundwater monitoring, in terms of air monitoring, that prevent the unanticipated consequences that you reasonably speak to. This is not your area, so you're unfamiliar with the way in which this occurs every single day, designed and implemented by professionals whose business it is to get it right, and regulated by professionals whose job it is not to be sweet-talked by a guy like Goldstein, right? There are checks and balances that are in place. Sites are developed in this regard. Contamination is contained and addressed, and life goes on. The world goes on. These sites are brought back into productive reuse, and they're done so safely, but they're done at great cost.
So what we're doing now, basically, is we're using our wells, we're pumping out the groundwater. In terms of the PFOAs, we're filtering that out, and then we have contaminated filters. Some of the other groundwater is filtered through plants and, you know, our normal bioswales are on the property. I guess what I'm wondering is, where are the contaminants going to be going?
If we do it correctly, they're not going to be going anywhere. They're not going to be traveling further off-site. We're going to implement these types of construction methodologies in a way that doesn't exacerbate the existing contamination, that doesn't knock more contamination out of the soil into the groundwater. As a practical matter, that doesn't happen, but we will be monitoring.
But so, I mean, isn't water still going to percolate through the site into the aquifer?
Irrespective of anything we do to improve the site.
It's percolating right now in the groundwater.
Yes, and we're pumping it out and trying to stop it. And that's what, like, are we talking about a giant swimming pool around the site in concrete to stop that percolation?
There could be membrane layers that put underneath ground to stop water percolating in the aquifer. But more often than not, development techniques. So special slabs that, and, you know, just building a regular parking lot with some improvements that allow, you know, prevent the permeability of the water through the surface, and then treating that stormwater runoff in ponds that have membranes on them that prevent it from going down into the aquifer.
It's sealing it off.
Yeah. Which makes me fearful, because we already have a problem with stormwater and keeping it on site. I guess what I'm getting at is, as I like some of the stuff that's been said. I feel like I need more information on brownfield remediations. I personally I'm not opposed to the idea. I don't think the city shares your same timetable as pursuant of a grant on October 5th, you said. This is an unsolicited bid. I'm interested in maybe hearing and having our staff research and request, you know, some other brownfield remediation professionals, just like, you know, when we're discussing what to do on COVID, we had Rob Lord come, and the Health Department come. I can say there's a couple things in the contract that scare me, as Commissioner McDonald pointed out, the title insurance, the rider states that you'll pay for it. The actual contract states that we're responsible for it. I know that's very minimal.
I'm sorry,
And,
the contract says the city's responsible for what?
the contract says the city's responsible for title insurance, and the rider says you are.
So the title issues we've negotiated at length with the city attorney who signed off on the agreement. If there's something about the agreement that you're not happy with respect to conventional commercial terms, we'll amend that.
Okay.
Okay.
I mean, it seemed, that is somewhat minimal, but there was a discrepancy between the two contracts. The rider states one thing and the actual contract in our attachment was different.
You may ask the city attorney to speak to that. We negotiated those issues at length, and I don't believe that there are any inconsistencies.
Okay, and I will
Well,
have,
The boilerplate in the contract did in fact say that the city was going to pay for it. You guys added language that said the rider supersedes paragraph 15,
Yes.
I believe. I haven't,
Exactly.
I'm pulling it up.
So there's no inconsistency. The rider supersedes the contract language, and that's true in several instances for that very purpose, to shift the equities in the underlying form contract in a way that's advantageous to the city. You'll typically see language that says notwithstanding anything to the contrary in the contract. And that's how you set that up from a legal perspective.
Actually, in reading in paragraph 7 doesn't have the language. Paragraph 7, it says seller has a legal capacity will convey marketable title to the property by special warranty deed, title evidence. Party pays the title insurance, will select the closing agent, pay for title search, including blah, blah, blah. Check 1, seller's expense. And then there's a subparagraph that says a title commitment by the Florida licensed insurer setting forth those matters.
I know we have a lot of lawyers in the room, and if we are moving forward, it just seemed to be tidy. We could just amend the contract.
Absolutely.
So it matched with the rider is what I'm getting at. I have a question for our city attorney.
It did one point say that.
We've had a lot of drafts. That's the intention, to comply with what the city wants and needs.
Mr. Mortel, so far we've gotten 3 amendments proposed, which I do like all of them. One was the buyer could agree not to disclose findings of their due diligence. Is that legal if they're dealing with the city?
I don't know how we would tell you.
That's a communication problem, I guess.
So
yes.
if I were your lawyer, Commissioner, Mr. Vice Mayor, if I were your lawyer, what I would say is that a buyer has no legal obligation to disclose its findings to any third party. There's nothing in state law that
But
says.
once the buyer discloses those findings to a city that's subject to the sub 119 of the Florida
That's
Public
correct.
Records
Becomes
Act.
public record.
That's right.
Public records.
That's right.
So you might
I'll-
come back and say, we choose
You
not
can't
to
tell
buy
us,
the
that
property. and
we can't get the results, or they get them.
Okay, and then, I guess the other 2 I've got in my notes, just to keep all my other commissioners, is the buyer's willing to pay for an outside consultant of the city's choosing to review the data. That would be a communication barrier as well if it's under public records law. And then the other one, which I really liked, because for me, the way I think of remediation is kind of, in a way, reforestation. That's really the best filter that we've come up with as Mother Nature. And you said of 5 or 10 acres sectioned out to be reforested for conservation or for a park?
So what I said was that we would carve out 5 acres for
Not
the
10.
city for park use.
I guess, I still really agree with you, Commissioner McDonald, about the hesitation that we don't have any, right now, we're doing a fairly well job, thanks to Mr. Peters. We don't have a ton of liability, as you said. I do see the benefit. I see the benefit and the value in the offer. I see it, though, bringing it up to a standard where it's residential use, not necessarily just in light industrial staging area for cars. But I don't know enough to know what those different levels are going to be. And I feel like I'd like more information on brown site remediation at this point. And I'm very skeptical that if we go down this path, you know, we're still liable up until you decide to close. Now, we might not know the findings of it, and they'd be kind of hidden in this area of you did your due diligence, but that makes me nervous from a transparency perspective. Whereas still right now, at least everything I know, I've been told we're doing a good job, and I've seen that in writing from the DEP, from our former Public Works Director, and now you, Mr. Goldstein, another professional in the field.
Mayor,
Yes, Commissioner Bruner?
this is also new to all of us, our commissioners, and they've asked a lot of great questions, good information. And when Commissioner Meyer was saying all of the state of Florida is doing this, so I'm thinking of all these landfills from the 50s, 40s, 50s that's been sitting all these years. Are these, and then I'm thinking, well, you know, maybe they're a lot cleaner. There wasn't that many people back in the 50s and 60s and the 40s. But why our landfill? If there's so many, why ours?
Why are we interested in your landfill? Well, number one, we were invited here. We were asked to submit a redevelopment proposal. It's what we do. It's what we're in business for. We think there's a good business model here, but we're passionate about this type of reuse as well. It's been my life's work for the past 30 years. It is
I need to make just a point of clarification for the record. It may have been Mr. McCarty that invited you here, but this is an unsolicited offer, and I have to make sure that the record's clear that the City of Stuart did not pick an individual corporation without doing a procurement procedure.
Thank you for that clarification, correct. We were invited here by Mr. McCarty, and we had very good and encouraging conversations with professional staff, with a development director, with a city manager who encouraged us to continue to explore this opportunity and improve our offer. Staff likes the concept, or at least when we started, things change, policies change, people change, politics change, I understand that. But we've been at this for 2 years and encouraged every step of the way to stay on course. We like the City of Stuart very much. We like its political leadership. We like the property from a redevelopment perspective. We like solving problems. We can see a very good end result here because we've lived it. It's part of our lived experience. We've seen this movie before. We very much want to be a part of the future story here, the jobs, the accelerated cleanup, the increase in tax rolls, the leveraging of the site for broader economic revitalization and equitable participation by folks who have a lot of access to opportunity and folks who don't have access to opportunity. The rapidly closing window for a job training grant is the tail wagging the dog, but it's still an important tail. And it goes to the various ways in which you can utilize this site for good public policy if you choose to activate it. The park, the commercial piece, the jobs. That's why we like it.
Thank you.
Thank you, Commissioner Meyer.
I just wanted to pick up on where Commissioner Vice Mayor Matheson was going. I think I agree with you in that this is, I mean, it's a lot. It's an unsolicited offer. It's been a liability for us for a long time. You know, luckily we have folks that have come and have showed us an idea of what it could be and walked us through the process. But I think I just want to take a breath and think about what it could be for us, not just what one one group of professionals, the best in the game, is preparing. I think if we were to go out to RFP, which is where maybe you were walking a little bit, I'm sort of in that direction as well, we probably would end up finding that this outfit would be among the best choices. But I think it would also allow us to have a little more idea of what else is out there and think a little bit more about, you know, what benefit this could provide to everybody. I guess, and I'm not against this at all. The redevelopment opportunity is great. The limitation of the liability is great. But again, I'm still also not clear on what the cleanup really looks like. You know, it seems to me like it's going to be, you know, we're washing our hands of it. You're taking the liability and you're going to put a liner on it, compact it, and then.
Not necessarily.
So, I mean, how are you going to deal with the PFAS? Like, that for me is, if we can't deal with the PFAS and you can, and you're going to protect the health of our great-grandchildren who are going to be living here and don't have that forever chemical, great. Can you, I mean, but you didn't tell me yet how you're going to manage that.
Well, that's because it's way too early in the process.
Okay.
We don't have any of our own proprietary data. There's not enough data. You have, I could bring up the diagram again.
If I could chime in, just for clarification, their responsibility to bring the PFAS into the compliance of the DEP, which as of today
70.
is 70 parts per trillion. It is not their responsibility to bring the PFAS to undetectable levels.
Right.
That's right. Thank you.
So,
There are very few data points in the landfill, I think 2 or 3. And so there are a lot of holes that need to be filled before we can come up with a plan. And by the way, the plan in terms of redevelopment always integrates the redevelopment itself. You leverage the site development work and the construction work to achieve efficiencies, performance efficiencies, and cost efficiencies in terms of the cleanup. So the answer to your question, what kind of cleanup? I'll tell you in about $250,000, because we need data, we need engineering, and we need to have a conversation with the city about what the city is willing to accept from a reuse perspective.
But you have established processes on your other sites where you have managed to bring PFAS, clean up PFAS to within levels, and you've.
No, sir, we didn't say that. We've not dealt in a redevelopment context yet with PFAS. I'm
Okay.
dealing with it now for about a half a dozen other local governments
Okay.
and private developers as well. This is the beginning of a long journey that all of us are taking.
Right.
Because it is an emergent chemical with still not well understood science or remediation practices. All of this is very new, and it would be an overstatement and a misrepresentation to tell you that we have any more experience than anyone else in this regard, because we don't.
Okay.
But we're going to figure it out.
Madam Mayor?
Okay, Mr. McDonald, I haven't said anything, but go ahead on.
So, after listening to this, I have, I guess I've come to a personal conclusion that that my concerns are outweighed by the rewards. Not to say I don't have concerns, I do. I think I do think that there are some long-reaching opportunities, and so I'm going to make a motion, but I want to add, there's going to be some conditions to it. And pretty much you've agreed to the conditions. One is, I just want to clarify the issue about title insurance and just change the box to buyer or pay title. That's a simple one.
Concur.
I want to, that you'll not disclose any information to Florida Department of Environmental Protection without consent to the city.
Concur.
Okay, that you will pay for a third-party consultant, environmental consultant chosen by the city to review the data.
Concur.
That you
In
would do-
advance.
Pardon?
In advance.
in advance, okay? That you will do a minimum of 5 acres reforested park,
Concur.
okay? And that, trying to think if there's anything that I wanted to add regarding the, and that any redevelopment ensures that any water that leaves the site, stormwater, is leaving at the at the clean, proper level, which I think we're gonna need that anyways. But I just wanna make sure that our stormwater is that there's a lot of attention put towards stormwater.
Concur 1,000%.
I-
We spent
I-
3
I-
slides talking about stormwater.
I don't know what the last condition was.
Yeah, I
That
think that, I think,
Stormwater design will comply with applicable standards for contaminated
yeah,
sites.
I think that our PUD process will cover that, but,
It won't.
pardon? So I'm gonna go ahead and make that motion, and that, and if there's any input from anybody else as far as condition, while I'm making the motion, I would certainly take.
I want to clarify.
Motion with condition, are we gonna have a second before we start
Well,
discussing?
I think Commissioner Meyer's gonna.
I just want, I had a
Okay.
question, because both you and the Vice Mayor had brought up this disclosure thing. So I understand, what we're talking about is, in doing your due diligence, in, assessing phase 1, phase 2 core samples, that if we find something really bad, that you can pull out, not tell us,
No, no.
Not
no,
tell
that's
the
not what I said.
DEP.
Before, I said not disclose it to DEP
DEP.
without.
If they tell us, they disclose
then they
it to
disclose
the
it.
DEP.
I just want,
So they
I
have-
totally
I-
I totally get the thought process there. I really do. But like,
It doesn't help us.
what do we think is going to be there? Like nuclear waste
Well,
or?
if they pull out, we obviously know there's a major problem that that it wasn't cost feasible for them to do it.
Right.
And then
What I don't want is the.
I would think so.
is
To
that-
increase our liability and,
Right, what I don't want is the DEP prior to, is my only real
Right.
concern is that they start the, what is it called, the remedial action plan process prior to closing.
Right.
And then, that opens up a can of worms where then they pull out, so I don't
They
want.
absolutely.
Then they won't, because
They
it's-
absolutely must have, the contract requires approval of the remedial action plan prior to closing. So
Oh,
they
it
won't
does
close
require
unless
that?
it's
I didn't
approved.
think it did. Because I thought it said.
Oh,
after-
no, they have to, well, they get a letter from the DEP, kind of like when we have a developer come in, and the
Okay.
DEP has to give them the letter that they can move forward, but it's not the final approval until they submit the permits to them at the end. It's a letter that they get from the DEP that essentially negotiates the remedial action plan conditioned upon certain things occurring over the next period of time.
I thought that was after closing. that-
Mr. Goldstein said it was after.
Yeah,
No.
I believe it's after closing.
The,
Mr.
the
Singh.
approval of the final plan is after closing. The submittal and initial approval by the DEP is before the closing. And I know nothing about brownfields for what it's worth here, but ask the
that-
men
is that-
before you
Where is
for
that in
the
the
accuracy
contract,
of that.
Mr.?
Because that's not what I
Where's
asked.
that,
that's
Mr. Mortel, in the proposed language of the?
It's not.
FAR contract, okay. So are you adding
You're
that to
saying
what?
it's in the writer? I don't see it in the
I don't
writer.
think, I don't think it's
It's
in
not in the
there.
writing.
Do you in fact submit anything to the DEP before you close?
No.
When
No,
you
we
and I
do
were
not.
discussing the indemnification, you said that you wouldn't indemnify it until it was approved.
No, no, no. There's no indemnification. Let's be very clear about
Right.
this. The city is not indemnifying
But you said
this.
you would bond the cleanup once
That's
it was
right.
approved.
Once the remedial action plan is approved, which gets submitted after closing, provided that we close, then we're going to provide a bond, because you rightly pointed out, smartly pointed out, what happens if you go away after you close and we're left holding the bag?
So you'll close without submitting anything to the DEP.
Yes,
And
we
then
are
if
willing
the
to do
DEP
that.
comes back and says, it's a $10 trillion.
It's not going to happen.
Well, I understand. My job is to look at the worst-case scenario. They could come back and say you don't have to do anything either, but
What
I'm not
could happen
assuming
is-
that either.
What could happen is, if we don't if we don't like what we see, we're not going to close. If we close, we'll work through the process to submit a RAP. If it gets approved, we'll bond the RAP. In the meantime, we have environmental insurance
Right.
to guard against
That indemnifies
unknowns.
you.
No. Okay, so it's not an indemnity.
So
It's
it covers you for exposure, but the environmental insurance does not cover Stewart, so let's not pretend.
Well, no. So the language, as you negotiated, provides that we use our best efforts to have Stewart added as an additional insured.
That was in rendition like 12, but then I was told that because Stewart was the person that created the problem, they couldn't be added.
No, we didn't say that. What we said was that we're going to use our best effort to get as much coverage for Stewart as we can.
And in my email, I said, then let's get it before the meeting.
No, it's not possible to get the
Well-
insurance now until we have the underwriting, until we
We're
have the
working
additional
off the
data.
language that we had, that
Right.
did say you'd use your best efforts.
Exactly, that's
But,
right. That's what we're going to do.
I mean, sometimes I use my best efforts in parenting my daughter, and she still has a temper tantrum.
Well,
Understood.
Madam Mayor, if I can, hold on a
You
second.
have a motion,
Yes,
What I want to ask is, when you say you use your best efforts to insure us as well, or to get us an insurance as well, if you are the owner of the property, that's what I'm trying to clarify. What liability do we have anymore? Why
So
do
here-
we want insurance?
Here's why.
when that applies.
plenty.
The answer is because if for some reason we go away, which we don't intend to do, I've been in this business for a long time, but if we go away, any party that was previously in the chain of title has residual liability.
Okay.
Okay? So this is a backstop against any claims, unlikely as that may be, being brought against the city. It would be logical for the commission to say, what's our insurance in the event that you go away? The answer to that is your insurance is insurance, right? That's why I went through the slides where I showed the best-in-class environmental insurance companies that provide environmental insurance. XL, Berkeley, Lloyd's, et cetera, okay? And why I put up a guidance documentation where EPA promotes the use of environmental insurance to facilitate these transactions so that nervous sellers can sleep at night, that they don't just have to rely on Goldstein having enough money in his back pocket.
Another point I'll make on that, Mike hit on it. We
come up
can't
to the mic, Mr. Kite.
We can't bind that insurance until we've done the appropriate testing to have the information to give to the insurance company so they can underwrite the risk and tell us how much it's going to cost and, what they'll insure up to.
But just for clarification, I feel like we went over this, and it was pretty clear to me that it wasn't going to cover the city because the environmental insurance that you would obtain is going to be, I think, a 10 or 20-year policy, and then it will be for both existing and new conditions based upon disclosures and feasibility. If, in fact, you were to find PCBs on the site, and it was a significant PCB matter, you're saying you could still get environmental insurance that would cover the cleanup for that, or are you talking it would cover just if it went off-site?
So let's talk about that. Environmental insurance is very interesting and very useful. For known contaminants, consistent with the notion you can't insure against a burning building,
That's exactly the thing.
right? You're not going to be able to insure for the cost of cleanup. But even with respect to known contaminants, you can get coverage many times for third-party bodily injury claims and third-party property damage claims. So if we discover that the contamination has migrated off-site and impacted, pick any adjacent property owner or operator, and they sue us and they sue the city for their inability to get financing or their inability to sell their property for X, now it's 60% X. Those types of claims, even with respect to known contamination, by and large get picked up by environmental insurance. What we are representing is that we will do, and I've placed a lot of environmental insurance, in a very transparent way. The city will be copied on every communication that it wants to be. We are going to ask that the city receive the same coverage that we receive. Many times when a insurance company is being asked to insure a seller, the insurance company will say yes, provided that the seller didn't cause the actual contamination, that they are as innocent as the buyer is. That's easy to do. We're going to try and make that case. Where it becomes more complicated is where the seller actively played a role and causing the contamination. That's a very hard pill for an insurance company to swallow.
Okay. We have a, did we have a second to Mr.?
And just as a point of clarification, one of the reasons that the city of Stuart is not
No,
allowed
we
to
do
share in the tax credits is because it created the condition.
Right, that's why we can't get our
Right.
brownfield cleanup ourselves, because
Yeah.
we're the polluting agency.
Yeah.
Which to me means that we're going to be the one that created the condition, which is going to make it really hard to insure.
Okay, here's where I'm at. To your right point, we are currently holding the bag. So, you know, we
I
might.
agree with you on that.
We
So
might
we
be
already have
holding,
that
we
issue.
might be holding the bag with them as well, but we are definitely holding the bag right now. You know, I'm not satisfied that we are completely protected in the future with you, but we're not protected right now. So,
And that kind of was my discussion. I let it go forward because after discussing it with the applicants, the situation was exactly that. The issue was, it was risk. You are exposed. There is no way to protect yourself from exposure, because if you do nothing, you're still exposed. There's no insurance if you don't do anything today either. I just wanted to be very clear on this record that there was no time that I ever thought that there was insurance that was going to cover the city of Stuart in this contract.
so when
Which is another hesitation.
somebody starts mucking around in there, I guess my question before was, well, why wouldn't we want to know if there was something crazy in there? But I guess the idea is that if you start digging around and you find something, then everybody's in trouble. But it's just the logic is so backwards to me. I mean,
Well,
if
and
there's
It is backwards.
if there's a serious health risk sitting in the landfill,
Don't you have a duty to fix it?
I mean, yeah, that's the thing that just doesn't make sense to me. Everybody's trying to play hot potato
If
here.
the FDEP is saying that you need to do something about it, that means it's posing a risk to health and human safety. So,
Right.
to your point, whether we find it or somebody else finds it down the road, it's still harming your residents.
We have the DEP saying, and multiple parties saying, we're doing a good job.
Aside
Well,
from
good job
aside from
isn't clean-
PFAS.
And-
Yeah, and wait till a adjacent property owner sells and they do an environmental and find out that the plume is spread into theirs.
So
But we're
But they
currently,
could find that if they sell their property
I know
now.
you've talked and stressed that you've been at this for 2 years, but for the 5 of us up here, you have to understand that this is the first time we can talk about this and that we've reviewed the data. And that's why I'm hesitant at this point. But from what I've heard, you have a lot of willingness to go forward, but there's definitely some reluctance and desire for more knowledge on the issue. And there's clearly some stuff that's not quite lining up with the discussions of insurance and not, but for the 5 of us, you need to understand that we haven't been communicating about this for 2 years, and this is new knowledge to us.
And also, as one other clarification, I need to be clear that I believe that the first contract was tendered to the city in 2021. That when they say they've been working on it for 2 years, Mr. McCarty and the applicant got together and started doing site reviews and looking at the site. They started approaching city commissioners and meeting with you. They were approaching city staff and doing other stuff. We have not been working on this contract for 2 years. It's what they've been doing as their due diligence to bring it forward.
I have a question for our city manager. We had CapTech look at the property.
Yep.
For me, that's what I'm talking about more information. Maybe the city can contact CapTech and ask them, and maybe we can be
I can also chime in a little bit to
by
the.
other brownfield experts that
So I think that Michael is absolutely correct in saying that no one is really going to know until they do the testing. So we could go to CapTech and say, what do you think of the landfill? And they can tell us historically that it was a stripped landfill and that there's 20-foot wide dirt, 20-foot wide garbage, 20-foot wide dirt, 20-foot wide garbage, roughly 15 to 20 feet deep. But when you say, well, what's the pollution in there? They're going to say, well, what'd you put in there?
but the thing is, we're currently, I mean, that site is currently being rained on. it's currently being monitored, and, it's actively, we've been actively working on it for the last however long, 20 years. So,
But I feel like it's a bag that I want to get rid of. I don't, we've been carrying it, and I'd like for them to carry it.
And I would too, and I would like it to never, ever come back. I can promise you that that would be my dream come true. And I feel the same way about the North Point.
Yeah, yeah.
I don't see the point, though, of having a consultant review after the fact. I see the benefit of hearing from a consultant.
Educate ourselves on
That
the
educates us
brownfield.
now.
Well, we could, if that'll
I
make
think you've
you
already had that.
comfortable.
I mean, CapTech already gave you guys that presentation.
Yes, we did.
Yeah.
How long has it been that we spoke? Has it been 2 years?
We've been working at this for about 2 years.
I
Now,
didn't
Mike
realize
is
it was that
correct.
long. Yes, sir.
Contracts weren't traded until, the last 9 months or whatever it's been.
Until the commission authorized us to negotiate with you on this contract in return.
Right. So, I believe, Dave, though, you did have some dialogue with somebody at the Treasure Coast Regional Planning Council that you were looking at to evaluate it or look at it, correct? And there was some dialogue you
Now,
had there with
Treasure
another.
Coast Regional Planning Council has a grant program that you can apply for a grant to determine brownfield and so forth. But we were working at that time with a different consultant on a different project, and it never followed through.
Okay, okay.
The city did investigation at some points as to what the procedures and process were to pursue a brownfield remuneration.
Right.
It was not any specific testing whatsoever. It wasn't specific site-oriented to the extent that it never got surveyed or defined. And the biggest hiccup that was always found is that the city couldn't qualify for
That's
the
right.
tax credits. So the only way really to do it would be to have a third party come in.
Right, exactly.
I mean, which is what brought us to this
Right.
moment in time.
Right.
Can
And
Commissioner
if
McDonald?
If I can just make an additional comment. When we talk about the city doing a good job cleaning it up, you're not really doing anything other than monitoring it. You're not really dealing with the root of the issue and trying to figure out how you solve the issue. That's my perception. You could spend $50,000 a year and do testing of the water and do these little nominal things that keeps DEP happy, but you're still not dealing with the contaminant and making something happen and redeveloping the site, whether that be a park, which is millions of dollars to clean up, to even make a park.
I agree with
So,
you, but
let's look.
Hold on.
what I'm not getting at is what I want to hear is from what's the best way to remediate it? And what we're saying is we don't know.
You don't know until they do the feasibility study.
Well, and
that's
if I could
what
just
makes
chime on
me
the
nervous
DEP
is-
part a second. There's a well 25 out there. The well is pumping water and putting the water back in the lake out there and essentially filtering that water and putting it in the lake clean again so it can percolate down in. It's having the effect of cleaning it through dilution and filtration, and it's also having the effect of pulling any flume back into and on site. The new game that the city didn't even know about when it entered into any of the agreements with the DEP on this landfill was what a PFOA is.
Right. Which follows the same kind of practice. But, so Commissioner, can you remind everybody what your motion was with your?
Yeah, okay, I'll try to remember. So it seems like it's been a lifetime ago.
How about the clerk?
I can,
So,
I can
okay,
get it
so
back
it's
if-
move forward. With changing check the box where the buyer pays title, where, let's see, we had the reforestation of a minimum of 5 acres. That can be a park, reforested as some sort of a park, that they do not make any submittals to DEP for the renewal action plan until after they close. They don't have to make the application. That they provide their data to us to have reviewed by a third-party consultant, environmental consultant at their expense.
Agree.
Yeah, and then finally, the last thing I believe was
Any stormwater.
the stormwater being, just ensure that the stormwater meets all proper standards, which will be required by the PUD anyways, but I just want to make sure that that's a reminder, because that's one of the most important things that
If there's
we-
a PUD.
Yeah, we don't know if it's a PUD.
or whatever it's going to be, PUD, whatever, but we have water quality standards.
Right.
And it
Well,
needs
and I
to
think
meet
that-
that at a minimum. And, you know what, if you can, I'll throw in there that you'll use irregular shaped ponds and littoral plantings because that we love those.
The reason I'm raising this issue is that when is it that they have to start protecting the runoff?
When
10
they-
years
when-
later when they apply to build the building?
When they build.
So if they don't build for 10 years, the water can run off,
Well, it's currently running off.
right? But that's after they own it.
I'm
So
sure,
if they remunerate, it should be upon completion of the remuneration, it would have the 2-foot stem wall or whatever it's going to be, or the 2-foot cap to be the PFO or whatever it is. It's at the completion of whatever that remuneration is, to me, would be when the water
Okay.
runoff is
that'll
also
be good, completion of the
protected.
remediation.
And I'm just looking for clarification. If that's a problem, tell me now. but-
Yeah, I'm happy to tell you if it's a problem, but I don't understand the proposal. What is it
So
specifically
what I'm saying is
that
that
you're asking
you're
for?
agreeing that any stormwater from the site would be meeting the applicable pollution standards, et cetera. The Commissioner McDonald's motion was that at such time as a development order was approved, or when you came and pulled the permit and built the building, you would do that. My concern is, we did a development order on a parcel called the North Point in 2005, and it's not quite broken ground yet. So if that was on that site, we'd be 15 years into it, and if in fact there was no stormwater preservation going on, there would be no protection that there was something running off or not. So what I was suggesting, that if we're going to protect that stormwater, and first of all, I'm assuming that whatever remuneration plan you do would make it so that that's probably covered anyway. But I
Do
just
you
want
mean
to make sure that.
remediation plan? I'm
Or
hearing
ren-
remuneration plan.
Remuneration plan would have some,
Remediation plan.
or remediation plan would have some protections anyway. But what I'm suggesting is that the commissioner's motion put a time frame when that stormwater standard would be imposed, and that it not be upon permit or construction, but that rather that it be part of that DEP plan, and that at the end of that, whenever that is under your agreement, it include that the stormwater will be protected at that time. It seems like it would be anyway, because the DEP wouldn't enter into an agreement that allowed above-level toxic substances to run off onto adjacent properties, but I just want to be clear
Yeah,
on
because
it.
that's not in our, because the commissioner's motion said it would be applicable to kind of our codes, like the stormwater. We don't contemplate that in our code, toxicity of
that's true.
stormwater.
So would that work for you? I mean,
Well, let me say this. We are going to apply, even if you didn't require it, we're going to apply with all of the applicable standards
Best
for
practice.
stormwater protection. That's why I've got these two guidance documents up on the screen, and there are a few more that follow it that speak to stormwater design and management on contaminated sites and the use of green infrastructure on contaminated
now,
sites.
would you build those sites when you do your remediation?
The stormwater structures?
Yes.
The stormwater structures are typically constructed when the site is developed.
That's what
That's right. And the remediate, keep in mind, we mentioned this a little earlier, the remediation is going to be part and parcel of the redevelopment, okay? And of course, there has to be a funding vehicle to pay for stormwater improvements. It doesn't make sense to redesign and construct stormwater drainage facilities when you don't have your structures even conceptualized yet,
that makes sense.
okay?
So I'll second the motion with with clarification. The 5-acre set aside I've heard, to be put into a park, and you said reforested for use as a
Reforested
park.
is-
So I just want to make sure, I mean, that's,
Let's talk about that.
yeah.
5 acres for a public park with forest elements
is that good?
as directed by the commission through staff.
Okay, so You know, I just want to make sure that, like, when, in my mind, an afforestation piece is of the forest, not just a couple sticks.
Right. We want
Lots
to
of
do a
trees.
bang-up job.
Okay.
Thank you, Commissioner Meyer. That was really a good thought. Need that.
Okay.
We haven't
So
heard
there's a
from-
motion and a second. I haven't had a chance to say a word.
Right.
By choice. I want to thank all my commissioners for talking for me about everything, the education, the liability, you know, what's going to happen when it's compacted, where does the methane go, what happens. You mentioned farming, and I wonder what happens with contaminants. When we reforest it, do we put the type of plants in there that is most likely to still grow but absorb some of that stuff and try to get the whole thing going, like a Chernobyl type of thing, you know, even though we don't know what's out there. But, and of course, the best practices. So I think everybody has kind of said all the notes that I've said, but I just wanted to say it anyway. So we have a motion and a second. And Clerk, do you have all of the
I believe I do, yes.
details that Commissioner McDonald has
Yes.
asked?
Yes.
I just have to say, there's one other thing that I want to be clear on. Paragraph 11 puts the burden on us to provide to them every single non-privileged document we have essentially on the landfill. I don't have any problem with saying to them, they can come look for it, but unless you guys are going to budget somebody to get those documents, that's going to be complicated.
I concur, whatever you want.
Okay. So what would you like, language would you put in, Mike?
I had 19 renditions where I said I wanted to take that out.
Okay. So,
I mean, we're subject to public records. We don't have privileged documents that people can't look
okay,
at.
so what line is that? Can we strike that?
They put it back in.
In the rider or in the FAR bar agreement?
It's paragraph 11
Which one is
of
it, Mike?
the
The rider?
rider.
5, 6,
And maybe it isn't, maybe it's out.
No, it's in there.
best practices.
It's in there. Thank you.
Delivery of documents.
11.
11?
So, and while we're talking about that, Mike, Mr. Mortel,
So you want to strike 11, Mike?
no,
I understand that they need documents.
Right.
I mean, they can't do this without documents. So I want to make sure that we agree that we're giving them access to whatever documents they need. I just kept shifting the burden from, this gives us 45 days to give them true and complete copies of A, all engineering and geotechnical reports, B, all environmental reports and studies, C, all surveys, D, all plans, plats, engineering studies, soil topography reports, technical reports, commitment policies, surveys, wetland studies, environmental reports, remediation reports, and oil and gas leases, if any. And that goes back, I'm assuming, to 1914, because that's when we started, but I know that there's not going to be much in the way of records back then. But 45 days is a fast time period, and I know I'm not going to get to it, so it's probably the clerk that's going to be responsible for it. And she doesn't know much about the landfill, so it's going to be hard for her to do it.
Well, just as some background on this, the standard time frame for turning over seller's documents to buyer is typically 3 to 5 days. We said that's too quick. We asked for 40, we offered 45, which we thought was fine. If the city needs more time, that's fine. These are conventional
I can start reading my
project-related
emails as it
documents.
relates to this. Should I? I mean, I'm happy to, but I wanted to be very clear on this record that I wrote emails that people probably don't like me for as it relates to this paragraph.
read them, sir. Let's hear your,
Why don't we change it to 60 days?
Fine.
What, can we, I mean,
thank you.
I mean, who's going to do it? What
Yeah,
if, by the
staff
way,
is-
when we're in breach, by the way, because we don't produce all the records,
So
the
do you
whole
have a
contract's off.
recommendation? What do you recommend, Mike?
He was speaking, but nobody would let Mr. Mortel speak. Let Mr. Mortel speak, and then Mr. Goldstein, and then if we have any of our motion persons who would like to speak.
My concern that I've expressed in every single email that it came up was that once the city's in breach of the contract, the city is not entitled to say that the applicant or that the buyer is in breach, because we breached first. The city will be breaching on day 46 pursuant to paragraph 11 of this contract, because we will not do it. We've never produced every record to anything because we don't have the resources and we don't have the facilities to know what every record is.
So what do you want to say?
Well,
said
I
he's
told
willing to
them,
do a
come
waiver?
up now.
Make
I
it
told them to come
available to
before the
them to
contract and
find.
come look at it. Look at every record they want.
Make the records available to them to find rather than us produce them and deliver
And
them.
I understand that it's impossible for me to say to them, okay, well, just figure it out yourself. We obviously are going to cooperate with them and try to give them everything. And I would agree, if I had everything in my office right now, this would not be an issue. I would just hand it to them. But unless somebody can come forward and tell me where these records are and what these records are, I don't have any. I just wanted to be clear, I don't have any records.
All known, how about all known records?
Yes, excuse me. Yes, sir, thank you.
Suggest this, we've asked you to trust in our good faith. How about we revise the paragraph and simply say, city shall use shall use good faith efforts. And then we extend the timeframe to 60 days.
And is there anything else in
I mean-
paragraph, hold on, Mr. Meyer. Same thing goes down in paragraph 12 where we have a 30-day time frame for something else. But I know that we're speaking of number 11 with regard to these items. Mr. Meyer?
I just wanted to say, this is a really big deal, and it's clear that our own staff is concerned about this. So I'm going to withdraw my second until I can feel confident that we're not going to be in breach of our own contract, screwing the rest of this down the line.
I can say and again, I have never litigated the word best efforts. I assume it's subjective in nature, and I assume that a very expensive trial lawyer could argue that if we only searched 55 search terms and we could have searched 155 search terms, that we didn't use our best efforts. I don't know how that plays out, and I want it to be very clear that what I said in the emails was, listen, I don't know what records you want. I don't know anything about brownfields. I don't know how this plays into it. I do not want the responsibility of being the guy that failed to produce the record because I didn't even know it existed. So if you want to come look at records, I'll meet you there Saturday. I mean, I don't care when, Sunday night at midnight, whatever time. And if it's, again, and I get it, there's a timing thing. Obviously, they don't want to incur the money and the time and the aggravation of doing it if they don't have a contract with the city. But at the same time, my concern is, we are going to breach it. I mean, there is no, and I don't know what best efforts means. I don't know what it is. We are statutorily responsible to give not just them, but everybody on the planet that asks every one of the records listed in that paragraph.
Strike the paragraph and we'll submit a public records request.
And that, I'm fine with that, because then I can cover it.
But Mary's going to have to do it anyway.
Yeah, but the difference is I'm not stuck with it in this breaching this contract.
Okay.
That's
If
fine
that-
with,
if-
that solves my problem.
Is that,
So we'll strike paragraph
And that's
11.
what I thought we had agreed on in
So
many
amend my
renditions ago.
motion to strike, to everything else stays the same, add strike paragraph 11. Mike,
and
do you re-second?
Mr. Mortel,
That makes me feel better. I'll sleep tonight.
okay, are there any other items in there that we need to make sure
I
you
have a
feel good
question.
There's a
about?
lot of
They know
language.
way more than I do, but we won't know until we know.
Can we can we give it a chance for you to go over some stuff with them? And this has a lot, to me, it has a lot of boilerplate language that sometimes got some numbers and some timeframes thrown in it, these 2 days and 3 days.
I'm
And
not-
if it's something that we're not gonna live with, I don't wanna,
I'm not so concerned about those timeframes. The title insurance, it has a special warranty deed. I need it to be clear on the record that everybody knows that there's going to be title issues with this because we are not going to be able to, you're not going to get clear title when you do the title search because it's going to turn out to be polluted. So with the exception of pollution, but I think that's gone without saying. I mean, we're kind of, right. And so from that standpoint, I'm okay with it. From the standpoint of it's not, my biggest concern has always been the production of these documents because I know we're not gonna, and that's solved because now that's not part of this contract. If we violate the state statute and cause them heartache, they have a different remedy against the city, which is fine with me, because we don't want to do that anyway. Right. And so the timeframes are not, the timeframes are not the concern. My two issues were those, like the production of stuff, and originally there was some affidavits we needed to sign, and I just knew we couldn't because we couldn't find a person to do it. And then the other one was the misnomer that we were going to be able to obtain insurance to somehow protect us on this. I kind of got past it under the presumption that Commissioner Meyer did, like, well, if we don't do this contract, we're not getting insurance to protect us on it either. So, and talking to the applicants, they said, you know, we're going to spend $250,000 doing research and take some risk on here. The city's going to have to trust us and take some risk on too. And quite frankly, it's a policy decision. It's not my decision to make. I just wanted it on the record. And those were my two issues.
All was
Mr.
seconded.
Vice Mayor,
I have a question regarding some language in the contract for you, Mr. Mortel. It's in the contract lines 142 to 144 that states, if the property must be rezoned, buyer will obtain the rezoning from the appropriate government agencies. Seller will sign all documents buyer is required to file in conjunction with development or rezoning approval.
We do that now. We did that
And I know
on-
that's standard language, but what I want us to not get into a trap in the future is that we, as the seller and the government agency, have to sign the application for rezoning.
So, and we had that debate too, and at one of the renditions, we discussed that the city, here, there it is, during the feasibility study period, the parties shall work together in good faith to create a development agreement for the property. That is the burden on the city commission, because that is your burden in any case. So if they came in and wanted to build a 6-story building and to rezone it for 6 stories, that paragraph 140, or line 144, doesn't mandate you to change the comp plan to 6-story buildings in the city of Stuart. It says you have to work together with them in good faith to develop an agreement for the property.
So
That also might mean that if they come in and say, we cannot get the DEP to agree to make this a daycare where children play in the water, you can't make that a condition of development because that simply wouldn't be good faith.
But-
If they came in and it was one of the things they demonstrated on their application and it met our comp plan and codes, you could good faith negotiate like you would with anybody else.
but they could come in and say, we want 5 4-story buildings with a density of 29 units per acre.
And anybody could. The
Yes.
question would be, if you denied it, would you be denying it in good faith, or would you have a reasonable basis to deny it? If there was a traffic concern and people couldn't get out, if everybody in the whole neighborhood was going crazy, I mean, or if it was just because you wanted to stick them and they could prove it, you'd lose. But that was the good faith. That's kind of at that line 331 is where we got on that, because I was concerned too, because I said, we can't sell development rights in a real estate contract. So we can't do it in advance. And we took it out and we talked about it, and we added that line 331.
Which
to
is in the
talk-
rider that supersedes this contract, so can
Well,
we?
no, that's line 331 of the contract where it says see rider attached in paragraph 20. On the page of the contract, during the feasibility study period, the parties shall work together in good faith to create a development agreement for the property.
It's the same thing we did when we did Azul.
Right, which is also why I thought that they were submitting something to the DEP in advance, because I didn't think they could do a development agreement before they knew, but I find that out now that they can.
Yeah, well, but at Azul, you had a concept plan of a residential development.
We did, no, when we initially sent it out, when we initially sent it out for RFP,
Yeah.
no development plan at all. We let them just come up with it.
Listen.
But let's do this. Good faith runs both ways. We have all the faith in the world that we're going to be treated fairly, so just strike the language.
Line 144 or whatever it is.
142 to 144.
I don't,
Okay,
fine
if
with that.
everybody's, if both the attorneys.
Commissioner, is
agree
that
with
acceptable?
I can, Mike, are you okay with that?
yep.
Meyer? 'Cause,
I didn't make the motion, but
I mean,
yes, if,
okay, strike those lines.
Yep.
And just for the
And I'll
record,
amend
we
my
did
motion.
discuss this, and it was both of our intention that they recognized that the city wasn't selling a mandated development.
Clearly.
In fact, that's why they didn't even present what their development is. And we put at the end that you guys would have to be in good faith and cooperate, just as you would in every application. You have to follow the code. You can't just ignore it.
And which is
Can't
why
be
we don't even
arbitrary
need the
and
language.
capricious.
So the addition of the striking is to Commissioner McDonald's original conditions,
Yes.
correct? Okay. thank you.
Yes.
And it would be lines 142 to 144
Starting with if the property must be rezoned,
on line 142.
yes. And ending with development or rezoning approval.
Okay, agreed. And I can go through that tomorrow with them.
Madam Mayor, you have a motion with no second.
Yes, sir, I heard that. Commissioner McDonald and Commissioner Meyer. And we have
Thought that was
discussion.
withdrawn.
So do we have any members of the public who have any comments
Did you
on the
resecond?
motion?
I thought he withdrew his.
He
Mr.
withdrew.
Meyer had,
Bruner
He
approved.
withdrew his second.
I withdrew my second until we got the,
oh, so we don't have a second then?
No, back
Oh,
to-
Commissioner Bruner, sorry.
Commissioner Bruner.
Thank you. Thank you. Mary, I thought I heard that you were telling me about Commissioner Bruner?
Commissioner Bruner seconded the
Okay.
second time. The motion was.
All right, thank you. So we have a motion and second. Members of the public? Public comment? Public comment on resolution number 69, 2021 regarding the landfill property and the discussion we've just had for the past umpteen hours.
If you think this was a while, you should have seen the other side.
Yeah. Any other comments from a board or board?
yeah, I just wanted to ask you, Madam Mayor, you've asked a few questions, but what are you thinking about all this?
God, I'm just thinking, I had the same concerns about, if we needed to educate ourselves or if we needed to go back and get them to iron out some things and possibly come back to us. But I think that Commissioner McDonald has illuminated and said all the things that I think are important. I do have concerns when I was going through both the FAR bar form as well as the rider, that there were some things that were very, very, they're all boilerplate, and if we were, just including some things that we needed to look into. I'm glad that Mr. Mortel was very candid with us and went through some of these paragraphs that we may not have brought up otherwise. And I'm also glad that Mr. Goldstein is so transparent and willing to provide us with information. And so I think that was good. I did had a question on he had mentioned something about farming, and I thought, how does that work with contaminants? And he had also mentioned something about having buildings raised on pylons. And, but I think that because we don't have a plan and there's so much that needs to happen in the very beginning of this to even get the evaluation and assessment started, I think it's going to be a step. It is $100, and Mr. Mortel, with your advice, I would not want us to do any breach and then have to end up having something, whether, I don't know, we'd owe them money or they would sue us for anything or any type of damages. So we want to be very careful on how we proceed on that. And I'm hoping that we have, we're working on all the proper steps now to make sure that both of us will balance out on this. And
In speaking with the other side, and just for pure clarification, there is no broker associated with this contract. The city's not liable to any broker, and there is no broker involved in this transaction. Whatever they do in a third-party transaction is their business.
That's correct.
Okay.
just, for the public who's here, and I know that this is the first item on our action agenda and has taken a little while, we appreciate you bearing with us, but I think Vice Mayor said it adequately. This is our first, we don't talk about these things with each other except here. And our job is to be transparent and also to, to just be able to get the information. And we probably could have had a workshop on brownfields with either the Regional Planning Council or with an attorney or somebody who's done this before. But we're here now, and I think that it's a big step to try to move forward on this. So,
Okay, I just wanted to, we don't talk very often, and I just wanted to suss you out, because sometimes you're hard to read.
okay.
How you feel about this as a project overall?
Nobody ever knows how I feel about this as a project overall. No, and the other thing is this, Mr. Mortel, since I know that this is more on a contract level, but since they might come in at in the future, it's been sold, and then it's up to them to do whatever they need to do. But I was wondering if I should ask, it's not really quasi-judicial, if I should ask my commissioners with regard to any disclosure of anything with regard to this property, that we need to do any disclosures or anything. I know that I've spoken with them.
The commissioners have a duty to disclose if they have a
Right.
conflict of interest and cannot vote
Yes.
on that. And if they have a inure to their own benefit or to a member of their family under the Ethics Commission, they also have a duty to disclose that and can't vote as well. If they don't disclose it, we're assuming they don't have it.
Yeah, I have nothing, and you know that I've spoken to them when they came in with their ideas and when Mr.
But this is,
McCoy
and this is
brought
not
them.
a,
That's
this
not,
is not,
it's not anything like that. I
yeah, this is not a
understand.
quasi-judicial approval.
I understand completely. Madam Clerk, are you ready?
I am.
Yes, ma'am.
Okay, Commissioner Meyer,
Yes.
Commissioner Bruner,
Yes.
Commissioner McDonald,
Yes.
Mayor Clark,
Yes.
Vice Mayor Matheson.
Yes.
Motion approved.
Thank you.
Thank you, gentlemen.
Thank you,
the end?
gentlemen.
Was that the end
Thank
of the
you,
meeting?
Mr.
Thank you so
McCoy.
much.
Yes, sir.
Oh, no, it was the first item.
This is the first item.
We did get through the consent agenda.
Now United Way gets their 2 hours.
Memorandum of Understanding with the United Way for the Born Learning Trails.
This would be Resolution 87-2021, a resolution of the City Commission of the City of Stuart, Florida, authorizing the city manager to enter into a memorandum of understanding with the United Way of Martin County for the installation, promotion, and maintenance of Born Learning Trails, providing an effective date and for other purposes. In full disclosure, I did not put any environmental insurance in this, nor did I disclose any PFOAs.
And I'll move for approval. This is great.
I promise this will not be long, and it will be fun, because I have to do a selfie first. It's what I do, and we have to have a little bit of laughter, because it's been a long 2 hours, so.
Are you tall enough to do that?
Get you all? All right.
Get in there. There we go.
Okay.
David clearly knew it was coming,
Okay.
but not enough in advance.
He's ready. Did you get Commissioner Bruner in the corner?
I just had to get Troy and I, full
You went
disclosure,
through
went
leadership
through
together.
leadership together, so.
The Great 28.
This is going to be something amazing for our community that we would like to pilot with the city, the Born Learning Trails. So just what are Born Learning Trails? They are 10 interactive signs that go out through a park. It's really to help children learn and get them outside and encourage them about outdoors. Did you know that for 19 months, we've been really, you all know this, trapped. And we want to encourage this type of activity. So I'm going to go through this quickly. Why do we need it? Children are born learning, and it is incredible. And Merritt, you know this. I'm sorry, Commissioner Matheson. You know this because you have little ones, and you know that they are like sponges. And so the more that we can read, talk to them, encourage them, the better it is for our children. Why do we need the Born Learning Trails? It is a proven fact that for children in low-income families, there's a 30 million word gap by the time they're 4, because people with higher income levels tend to talk to their children more. You can tell if you ever meet my kids, they talk a lot because I talk to them all the time. But this is really important, and we want to make it fun, interactive, and whatnot. It's so important because our kindergarten readiness scores, I don't know if everyone knows this, but it has gone down this year. Prior, we had 51% of our children were kindergarten ready, which is not good. It needs to be better. It's down to 47%. So again, this is helping them from the beginning to make sure that we can work on those numbers. Also, in addition, our third grade reading level has also gone down by 2 percentage points over last year. And COVID has a lot to do with this. So there's no blame anywhere, but we really want to encourage this type of activity. So what we're looking for, oops, let me go back, is we've identified 3 parks that we'd like to put these trails in. They are at Flagler, 10th Street, and Kiwanis Park. We are working with sponsors, we're working with your city staff, and we want to get this done and up and running. I know I'm going quickly, but it's an easy sell. If you look, this is what we're looking for. The signs would be both in English and in Spanish, and you can see that these are just some of the examples that we would be looking at, having that through our parks and having the opportunity for parents, grandparents, and caregivers to walk and talk with their children and questions.
What is that material? Is that paint?
Yes, it's paint, and we would actually work with the sponsor of the trail to help put all of that in and paint it and maintain it and help with it on an annual basis. What we're asking the city is like cutting the grass around the signs and whatnot, but it is a true partnership.
Move for approval. Second, and what's the timeline?
As soon as you say yes, we have 2 sponsors that already have said they want to be a part of this, and I know I have a third.
We've got a motion and a second.
I'll see, I
There's
wanna
been a-
go, I wanna see you out there working tomorrow. Get your paintbrush.
Yeah, it might
There's
be.
a motion and a second, Commissioner McDonald and Commissioner Vice Mayor.
Yeah.
Is there any member of the public who has any comments on Resolution 87, 2021? Thank you. We have thumbs up now.
Good.
Thank you. That's what happens when
It's
you're
kind of like the
tired.
like button on Facebook. They just put their thumbs up.
Yeah,
Thank you for your patience.
thank you.
We're gonna have to hand
City,
everybody a thumbs up. and a
City
thumbs
Clerk?
Commissioner Meyer,
Yes.
Vice Mayer Matheson.
Yes.
Mayor Clark,
Yes,
Commissioner McDonald,
Yes.
Commissioner Bruner.
Yes.
yes, thank you.
Thank you.
Thank you. I thank you, Ms. Howard Diaz, thank you. Item number 9, to accept the US 1 Corridor Master Plan, which is item number 91-2021. We have the Regional Planning Council, and we have Mr. Kevin Freeman.
Thank you, Mayor. This is a resolution to accept and approve the master plan for the US 1 corridor study area. This was initially brought forward to the Commission some time ago as a result of a community planning technical grant from the DEO. We entered into an agreement with the Treasure Coast Regional Planning Council, and they did an excellent job, as they normally do, in gathering data and information and putting together a master plan for the US 1 corridor. That's the outline and location of the study area. It blends and meshes into the study areas in the city. It's quite intentional that now you're going to see in the future, and you approved earlier, initiation of the creek.
Mr. Freeman,
Sorry?
if we just take 1 second to read the resolution title into the record.
Sorry?
Sorry, I didn't get that. Resolution 87, 2021, Mr. Mortel.
It's resolution number 91.
No, sorry, 91, 2021.
It's resolution 91, 2021, a resolution of the City Commission of the City of Stuart, Florida, approving and accepting the master plan for the US 1 corridor study area, providing an effective date and for other purposes. Back to Kevin.
Thank you, sir.
Thank you. I shall now resume. The outline of the location of the US 1 study area, the corridor forming the spine of the US 1 as it passes through the city, primarily into the center of the community redevelopment area. The study components involved economic baseline analysis, the existing conditions of the area, public input, stakeholder input. The components of the plan are included as a tour within the plan itself. And then there's a section on implementation tasks and projects. This plan was presented to the City Commission, believe it or not, in March of this year. When we come to look at the outline of the plan, which we see the study involving the relationship of land use, transportation, economics, and all the context that those involve together, and the recommendations made by the Treasure Coast Regional Planning Council in the master plan are four, in essence. Invest in the corridor with incremental improvements through the CRA, through CRA incentive programs, including proposed infill tree planting program. You saw a bit of movement on that earlier today, and the existing business improvement grant. Invest in the corridor with placemaking and safety interventions by providing lighting, transit shelters, crosswalks, and pedestrian-oriented intersections. Update the existing regulations to ensure desired street sections that promote consistent and predictable sidewalk and planting zone as redevelopment occurs. And encourage a realignment of uses on the federal highway corridor by studying changes to the existing future land use and zoning along the study area adjacent to downtown. And that will morph into place as we do further studies in the creek and the triangle, and even in East Stuart, when we're trying to coordinate and get a very good basket of uses within the city. So I do have Jessica here tonight, just in case there's any questions on the master plan, but other than that, I'm asking not to approve the abandonment, but to approve.
Clearly a cut and paste job there,
approve the
Kev.
plan. Thank you.
I move for approval.
Second.
Move approval by Commissioner Bruno, second by Commissioner McDonald. Any commissioners have any comments? Any members of the public have any comments? Members of the public have any comments? City clerk? No? Yeah. City clerk?
Vice Mayor Matheson?
Sleeping.
No. Commissioner Bruner?
Yes.
Commissioner McDonald?
Yes.
Commissioner Meyer?
Yes.
Mayor Clark?
Yes. Mr. Mortel, is it appropriate to have Mr. Vice Mayor vote when he comes, or does he have to be present now?
He misses the vote. Let's move on.
He misses the vote. Okay, thank you. Item number 10, well, I don't know, he needs to be here for this one. Creating a St. Lucie River Sinking Fund. And it's resolution number,
This is Resolution 98-2021, a resolution of the City Commission of the City of Stuart, Florida, authorizing the creation of a St. Lucie River Sinking Fund to be funded from 1150.531 professional services fiscal year ending balance, providing an effective date and for other purposes. We're going to have to wait a minute for the city manager to return because he was handling this
Let's
matter.
approve it before he gets back.
yeah.
We need two restrooms.
I did.
Item number 10, City Manager.
Yes, Madam Mayor, this is a resolution as a result of a request that Commissioner Matheson brought up during commission comments at our previous meeting. And this creation of this resolution would authorize a sinking fund to be created using the funds from 1150.531 at year-end balance to be placed into said sinking fund.
Madam Mayor, I'll make a motion to approve Resolution 98, 2021 to create a St. Lucie River Sinking Fund.
Second.
Motion by Vice Mayor Matheson, second by Commissioner Meyer. Do any of the commissioners have any questions on the resolution as published? Any members of the public have any questions on resolution number 98, 2021? I see Ms. McBride coming to the podium.
Figure I'm going to be here till 1 o'clock.
Might as well say something.
Yeah, keep me awake. Helen McBride from Flamingo Avenue. I'm all for it. I think it's a great idea, but I was a little concerned because I don't know which meeting was. The attorney said it was $5,000 he had as a balance. I don't know if that figure was right, but
I save enormous amounts of money, Helen.
I know you do, Michael. I'm pulling that 5,000 out, you know. But he did state that there was a case pending and from like, say, this year, and you haven't, the lawyer still, it's being carried over to next year.
The city manager did make some amendments to the proposal and put a cap on it and some other matters.
All right, that's all I don't want, then next year he comes up and says, oh, well, we have to come up with more money.
I'm still going to blame him if something goes wrong.
Oh,
Let's be
good
clear
for
on
you.
that.
Okay, thank you very much.
He can't blame himself.
Don't worry, Helen, you'll still be here till 1 a.m. Because I'm back. You probably wish I were still in France, huh?
Any other comments from the public? City Clerk?
Commissioner McDonald?
Yes.
Vice Mayor Matheson?
Yes.
Mayor Clark?
Yes.
Commissioner Bruner?
Yes,
Commissioner Meyer?
Yes.
Thank you. Item number 11, resolution number 99, 2021, regarding executing a letter of intent with Housing Solutions Council. And I forgot to also say that we had our former commissioner, Mr. Blunt, here with us tonight. They were so crowded earlier, I didn't notice, but Mr. Blunt, thank you.
This is resolution number 99-2021, a resolution of the City Commission of the City of Stuart, Florida, authorizing the city manager to enter into and execute a letter of intent with the Housing Solutions Council for a due diligence period of 1 year, negotiate a land lease, and return to the commission for approval, providing for an effective date.
Madam Mayor, I'll move for approval.
second.
Moved by Commissioner Meyer, seconded by Commissioner Bruner. Do any of the commissioners have any comments on resolution number 99, 2021?
I just wanted to be clear with the commission that the letter of intent states 40 to 50 units of 1, 2, and 3-bedroom units, and I had raised that as a concern because
I added section 3 to the resolution after you brought that to my attention that says the city commission is not entitling the property as outlined in the permitted use, quote unquote, section of the letter of intent. Further commission action is required for use and density approval.
Right.
the resolution is great, but the contract is going to be signed by the city. If this contract is signed, the contract or the letter of intent will be limited to the letter. And I know the intent of the resolution is that. I just want to go on the record and say tomorrow I'm going to handwrite the resolution also applies to this contract.
Okay, well,
fair?
I was under the impression that the resolution would satisfy that, so if it
So,
doesn't.
and I just want to make sure that the applicants know that I'm going to say that this letter of intent is also includes the resolution, and then
Okay.
we're good, and I'm fine with it.
If you're good, Mr. Mortel, then I'm good.
Thank you. Any members of the public have any comments? Mr. Martel, are we good in good standing to
Yeah.
take a vote with
You
the,
are.
with
And
the,
that goes to the exact same issue we had on the landfill, that you can't sell development rights.
okay. Commissioners, are you satisfied with what we're getting ourselves into?
Well, I'll just say that, we've been looking at this property for years. We've been talking to Housing Solutions for quite a while. They've been here at most meetings. They've been keeping us abreast. I know they're working really hard, and they need this from us in order to take it to the next step. So, this is not binding us to anything. This is just further giving them that intent that we want to pursue this partnership with them. So I'm all for it. Give them a year to get their ducks in a row, and let's hope that it works. And if it doesn't, it reverts to us, we're okay.
Mr. Meyer, you had asked me earlier in an earlier item about my opinion. I must say that it's not exactly like this, but I remember when Stuart Lodge on Palm Beach Road was coming in, and they had gone to the Industrial Development Board at Martin County. They had tried other things, and all they needed was a similar thing. It was like a letter of intent to get their financing. Nobody would do it. I had to work hard with our city commission to try to get that understanding out there. We stood behind it. It got built. It's successful. So I think that we can work with you on this and try to get you over that hump.
And there'll be a more formal agreement that comes back to the commission after they've done their due diligence anyway.
They said if this doesn't work, they'll take the landfill.
Yeah, I know. We'll give them that.
I got 5 acres of forest then.
You have a compacting ball.
It's the same forest you find in the Publix or the Target parking lot.
I wish you all the best of luck. We are in desperate need.
Thank you.
You sure are.
Any public, did I ask for the public already?
Yes.
Commissioner. She's gonna be a commissioner one day. Clerk, Madam Clerk?
Mayor Clark,
Yes, ma'am.
Vice Mayor Matheson,
Yes.
Commissioner Meyer,
Yes.
Commissioner McDonald,
Yes.
Commissioner Bruner.
Yes.
Thank you so much. Thank you very much, Mr. Blunt and Miss Greenwood, thank you. Let us know how things are going. Well, we'll tell you how things are going. Thanks.
I'm only
Second
going
reading,
I'm only going to read the ordinance, the ordinance 2464-2021. It's the ordinance of the City Commission relating to the Sport Fish Marina, UPUD. The only reason it's on the agenda tonight
Wait,
is
we
to...
skipped,
you
we
skipped
skipped
number
second reading,
12.
the abandonment.
Oh, I didn't skip it. I
Number-
just was moving on.
Oh, you were
I actually had touched it earlier and it was purple.
Now, that's an attorney answer.
I'm sorry, it's ordinance 2474-2021, an ordinance of the City Commission of the City of Stuart, Florida, authorizing the abatement of a certain right-of-way within the city limits, being that portion of land which lies between Southeast 16th Court and Southeast 18th Street, which is more fully depicted in Exhibit A attached here too, providing for an effective date and for other purposes. And I also attached to the agenda that it be conditioned upon and it's in the resolution, the abandonment be conditioned upon the recording of a public utilities easement.
Thank you. Mr.
Abandonment, not
Mortel, can
abatement.
you cover me on
I'm
this?
sorry, abandonment, yes.
What is it? What's the language?
If I said abatement, it says abandonment in the ordinance.
For me, for me. I'd like
Part you
to,
just said,
Oh.
that you fixed.
You'd like to recuse yourself.
I live there.
She has, that would be a Form 8B voting conflict, just because it inures to a financial benefit.
Okay, so clerk will take care of that.
Second, has anything changed?
Motion by Commissioner McDonald, second by Vice Mayor. What was your question, Vice Mayor?
Has anything changed since the last reading besides the addition you stated?
Staff consulted the neighbours as requested. We had one response from one property on the 16th Court who was satisfied with the proposal.
Okay, a couple of my neighbors told me they got a letter. I probably got one too, but my husband hid it from me. Motion and a second. Is there public comment? Clerk, have I sufficiently declared that I am not going to be voting on this and I will sign the form?
You have, I'll provide you a form.
Thank you. Clerk?
Commissioner Bruner,
Yes.
Commissioner Meyer,
Yes.
Commissioner McDonald,
Yes.
Vice Mayor Matheson.
Yes.
And Mayor Clark, just for the record.
I have a conflict and I will not be voting.
Thank you.
And I'll sign the proper forms that are required. Thank you. Mr. Mortel, could you please tell us about item number 13 individual as well as item
Let
number
me try this again.
14?
Item number 13 is ordinance 2464-2021 regarding Sports Fish Marina UPUD. The development director included this on the agenda item because there was neighbors and others that wanted to attend, and he didn't want to just take it off and have them show up and be disappointed when we didn't talk about it, but it's not being continued to a time certain. You can ignore it or move to continue, and we can move on, and we don't have to set it to a set date.
Move to continue.
Second.
And you can do all in favor.
Aye.
Okay, thank you.
Aye.
Aye. Thank you, Mr. Mortel.
I didn't call the vote. I said you can do all in favor. I was talking to you, Madam Mayor.
Okay, I appreciate it. Clerk, are you satisfied with the action on number 13?
I am, thank you.
Okay, number 14, Mr. Mortel.
This is ordinance number 2472-2021, an ordinance of the City Commission of the City of Stuart, Florida, amending the future land use map of the city's comprehensive plan, thereby changing the future land use designation from commercial to multifamily residential for a 9.43 acre parcel annexed by ordinance number 1527-97, owned by Ted Glassroad Associates FL LLC, located on the southeast corner of Southeast Indian Street and Southeast Commerce Avenue, said land being more fully described in Exhibit A attached, and further providing that said lands shall concurrently be rezoned from Commercial Planned Unit Development CPUD to Residential Planned Unit Development RPUD on the city's official zoning map, establishing the Silverthorne RPUD consisting of 86 attached homes, approving a master site plan, providing for development conditions and a timetable for development, declaring the plan to be consistent with the city's comprehensive plan, providing directions to the city clerk, providing for repeal of all ordinances in conflict, providing for severability, providing for an effective date, and for other purposes, and the staff is seeking that this be continued to the November 8th, 2021 City Commission for a time certain.
Move to continue to November 8th.
Motion by Commissioner McDonald, second by Commissioner Meyer. Is there any member of the public who has a comment on item number 14, resolution number 2472, 2021, to continue Silverthorne PUD to November 8th, 2021? Can we do all in favor?
It's it is a continuance, so yes.
Okay, all in favor?
Aye.
Aye.
Clerk, is that satisfactory? Mr. Martell, is that legal?
Yep,
I don't want to do anything
It's continued to
that-
November 8th, 2021, set time, set certain.
Thank you. Item number 15, addition of new property rights element in the comprehensive plan.
This is ordinance number 2473-2021, an ordinance of the City of Stuart amending the comprehensive plan, adding element 12, a new property rights element, amending element 1, future land use element, providing for an effective date and for other purposes. And I would like to announce to you tonight the debut.
And nothing has changed. Nothing has changed, Mr. Freeman or Ms.
This is a
Aaron?
first, this is a first reading.
This is our first.
This is her first City Commission presentation.
Oops, Aaron.
Way to put the pressure on. Good evening, Commissioners. My name is Erin Wootka, Senior Planner with the Development Department. This is the first reading of ordinance number 2473, 2021. Oh, I think he just read it. Yeah.
I read it, yes.
So this
Just
is to
title.
establish a property rights element within the City of Stuart Comprehensive Plan per the requirements set forth in Florida State Statute 163.3177. It's also to strike existing policy 1.A7.7 in our future land use element in regard to property rights. We already have some language in our comp plan, so we're striking that existing policy and we're incorporating it within the new property rights element, which is going to be element 12 in the comp plan. And then finally, we're resolving an existing issue within the table of future land uses within element 1, removing the mandatory requirement to have 25% of residential within the marine industrial designation by increasing the non-residential limit from 75% to 100%. And Kev will go into further detail on that in a minute. So Florida State Statute Section 163.31776I1 requires each local government in the state of Florida to include in its comprehensive plan a property rights element. What we have done is we have taken language from the Thousand Friends of Florida to incorporate to meet that state requirement. And then I'm going to give this to Kev.
And
So do you want to stop there for a moment and discuss the property rights element? There are other, let me just go back to that. What we've done with a property rights element within the comprehensive plan is we've looked at the model from the Thousand Friends of Florida and looked at what parts of that are required to meet the state statute. And that was our aim with this particular discussion, is to meet the state statute, get it in the comprehensive plan, create the element. Now, there are other policies and objectives and goals within the Thousand Friends of Florida model that have some serious impacts on the land development code. And I think we would need to have commission direction very precisely on some of those issues before we incorporated them into the comprehensive plan. There are issues around notification. There are issues around the processing of lots of different zoning or future land use applications, which we cover within the land development regulations. It's significant. There's significant changes to the procedural ways that the city would carry out its review and processing, and the impact on that would be fairly substantial on the review process. So I think that it really deserves a a wider discussion on those pieces. They're not mandatory. We would meet state statute with this amendment alone, but I would recommend that staff come back and talk to the commission around the other pieces of this, which are far more impactful on both the comprehensive plan and the land development code and the way that the city processes development applications.
I'd like to add one thing as well. The state DEO will not actually accept any future land use amendments at this point. So we do have a ticking clock in terms of meeting the state statute. And so it is our recommendation that we move forward as such at this point with element 12 for the new property rights element. And we can come forward in the future after having a lot of analysis and discussion about those other items.
If I could chime in, the LPA voted unanimously to approve it as is, and I recall the county adding one of these conditions a couple years ago, and it was the one that made the minority control, because one of the conditions is that in order to pass anything, you have to have 4 votes or a supermajority. So if 2 people vote against something and 3 people vote in favor, the 3 in favor still lose and majority doesn't control. And I thought it got challenged. I looked this afternoon and was unable to find it. I know that the county has reversed it, but I don't know if it was challenged. That's one of the concerns I have, is that there was a big outcry that it made a minority vote actually control on the dais.
So I have a few issues. I think staff is trying to address them before I've brought them up, but
Okay, Vice Mayor.
I like 1,000 Friends of Florida, and I see their recommendation included 2 other objectives. So I think it's not that accurate to say you copied the language from 1,000 Friends of Florida. I mean, they state policy, what we're calling policy 12.1 to 12.4 is required. So I guess my first question is, why did we add policy 12.5 to 12.8? Because those seem to remove our rights as a commission even further than what we're required by a Florida legislator. And 1,000 Friends of Florida clearly states, well, they don't talk about those at all. Those aren't suggested language from 1,000 Friends of Florida. 1,000 Friends of Florida says what we have as policy 12.1 to policy 12.4 matches their model of the requirements by state statute in Objective 1. Then 1,000 Friends of Florida goes on to suggest Objective 2, which they label as transparency. And it says, identifies the rights of people to participate in decisions that affect their lives and property. The objective provides standards for local government. Decisions to be transparent in respect for this right. We didn't include any of that.
But if I can go on and talk about that for a second, because what it said is that a variance is not allowed without following the rest of the agendas. So the City of Stuart could no longer, the Board of Adjustment would be disbanded the day you approve that, because they can't handle anything after that day without a comp plan amendment or without a 30-day pre-meeting notice to people within 1,300 feet instead of 300 feet, and then another 10-day notice to the people within 300 feet. And like this agenda item went out on Wednesday. We couldn't be hearing this today because it's not a 10-day notice of the language in the ordinance. And then you making the changes would cause it to be stopped again. All the new notice would have to go out again.
No, you're digging way too far into it. We just removed their objective.
Policy,
Their policies under the objective state 10 days. We
10
could
days
pick
bef-
other
right.
dates to discuss that, but we didn't. I mean, that's my issue is 1,000 Friends of Florida suggested an objective 2 on transparency.
ironically, though, if I can tell you, what they said was, Florida law recognizes the due process rights of people who are parties to many local governments. And they cite Brevard County versus Snyder, which means it's already the law. They already are entitled to due process. And Jennings versus Dade County, which also says they're already to due process.
So why are
And then
we
they've also
adding-
determined that our 5-day Wednesday to Monday meets due process. So we've already meet that standard right now, or else we would be violating Florida law. But they want to create an objective and they want to infer that these cases tell you it needs to be 10 days. They don't say that. That case does not say 10 days. It says due process.
Exactly.
But this is due process. So 5 days is due process. Reasonable time is what due process is. So the question becomes, do they extrapolate the case law and put arbitrary objectives, which, by the way, 10 days is an arbitrary number.
Okay, you added the 10 days.
No,
Yes, I read the objective. I didn't get into the policies of it. We don't even have objective 2 in the recommendation.
Correct.
Nor do we have objective 3. We haven't even gotten into the policies under those objectives.
Commissioner Matheson, if I could just have a moment to address your comments. So those additional policies of what you're seeing in there, that's the cross-referenced element, policy 1.A7.7, that we have existing in our future land use element. That's what we're striking from the future land use element and adding into our new property rights elements. That's existing language in our comp plan that we're moving into a more appropriate place. So it's really just a housekeeping cleanup item.
It's just moving that.
Okay.
And then in terms of following
12.5?
Friends of Florida, what we did was we followed the objectives and policies as required by the state statute and using the 1,000 Friends of Florida language. We chose not to include objectives 2 and 3 because of the potential issues and conflicts with our land development code. So that's what I was saying in the presentation is we can always revisit those and look into and having a deeper analysis into that in the future and coming through with a comp plan amendment that addresses those things that you want in there. But this is specifically to meet the state statute requirements, so we're in compliance with state law.
Okay.
And just to add, I think those objectives make sense. I think having those objectives around, but I think we would, when we're talking about objectives, we will need to have policies that implement those objectives. So, your idea of putting something in about transparency or an objective about that, then let's work out the policies that go with that to give it some
Exactly.
teeth.
So to me, if we were
Yes.
modeling off of 1,000 Friends of Florida, but we wanted to tweak it to ours, we would adjust the 10 days to 5, not
Right.
remove the objective.
There are more issues than the 10 days in these, and I think to do a piecemeal of these objectives, it does the city a disservice, and it does you a disservice as a commission in that you're not wrapping up everything as a package, and that's why staff would recommend that we come back and we go through the objectives that the 1,000 Friends of Florida have. We analyze the impact on the process and the land development code. We bring that forward. We may, as a result of that, bring forward suggestions of how those objectives and policies best fit into the processes of the City of Stuart. And if the commission aren't happy with those processes, this would be an opportunity to change those. So it's not that we deliberately aimed to remove these because we didn't like the idea of them. It was because we wanted to have a better analysis with the timescale that we have to do that and give you the better information to make
And our
decisions.
time limit to changing this is with our first comp plan. We have to comply with
Which we've
the
got
state's-
coming up, yeah.
And the rush to do that, though, is the desire for Section 2 of this,
Section 2 of that,
to clean up our comp plan. I mean, we can't,
yeah.
unless we pass this right now and rush to pass this, we can't adjust that marine industrial requires 25% residential. Is that correct?
it was an opportunity to put that in. I believe it's a scrivener's error in the table. All other future land uses allow 100% variation either way. And in this case, it actually mandates, if you look at the proportions, it mandates residential. And of all the future land uses, marine industrial is perhaps the one that you don't want to have to mandate 25% residential in there. So it was an opportunity to remove that scrivener's error, and that was really the basis of that. And it's in the same element 1 as the objective that we're striking through and moving into element 12.
I understand the need for this change. What I don't understand is the rush of this change dictates that we have to rush to comply with the state statute.
We have future land use changes coming through under development proposals, which the Commission will likely see in the very near future, that is the rush. That is to have this in place.
The agenda item we continued to the next meeting.
Will be a plan
includes
amendment.
one.
Exactly, so we're
So we need this
changing,
adopted
though,
before it.
the other objectives to comply with state statute, but we're not doing it properly to rush to change this change.
Well, by the way, we can discuss the elements right now. We're here.
Can I,
Yeah, I hear you.
may I understand where you're coming from, Vice Mayor. I've been working, we had a presentation on this, well, I was working on it with the Florida League of Cities, and then we had a presentation at the Council of Local Governments by the Regional Planning Council. The Regional Planning Council's position, and you know, we trust them, we love them, is keep it simple, stupid. They have said over and over again that because this is a new element required by state statute, honestly, our existing, the cleanup we're proposing, our existing policy 1A77 is more intense than the property rights element required by the new state law. Let's keep it simple. You're right, 1 through 4, that's required by the state statute. Let's just put that in there. I would even suggest we strike 5 through, even though it was in the code before, the recommendation by the Regional Planning Council, and not Friends of Florida, but other planning organizations, is just start with the bare minimum that the state is requiring, because it's going to be litigated, it's going to be figured out. We have the opportunity right now to strike this, 5 on, and reverse to what the state is requiring, bare minimum. Let's do that. Let's let all of the chips fall. Staff can work through, because I agree, I think long-term, the Thousand Friends of Florida's recommendations are worth us exploring, but all of the planning organizations, well, obviously not Thousand Friends, but the regional planning councils are saying, hold on, take it slow, go simple, just do the bare minimum that's required by the new state statute. In fact, Wildwood, Florida, they're the first one that has incorporated the new property rights element. They exactly boilerplate, 1 through 4. That's what they say. It hasn't been challenged.
I'd much rather do that and revisit the entire recommendation. To me, it seems like we're trending too far the opposite way.
It looks like a lot, but I mean, staff just said, what they did is, we already have the existing property rights references in future land use element. They're adding the required language.
They're shifting
And
that.
they're shifting the stuff we had below that. So I would make the recommendation and make a motion that we just have our policy and then objectives 1 through 4,
I'd second that motion. I mean, that,
as required by code, and we'll remove
Revisit.
altogether 5 on, because that's not required anymore. Is that okay by staff?
Yes.
I want to look at that statute ordinance real quick.
Is there a motion and second? Is there any other discussion? Do you have discussion,
I understand, but sorry.
Mr. McDonald?
I'm just looking at this a little bit, so.
Continue, Mr. Matheson.
I understand the sense of urgency for one issue and the desire, and that Florida law now requires us to address this other issue. But thank you, Commissioner Meyer.
Yeah.
I mean, I would agree, if we're going to discuss revisiting it, let's do the bare minimum that we comply with Florida statute.
For clarifications, from my understanding, is what you're suggesting is goal statement 12 in the ordinance stays there. Objective 12, policy 12.1 through 12.5, I'm sorry, through
Oh.
the end of the page, 12.8.
No,
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 12.4.
it's through 12.4.
I'm saying element 12, goal statement 12, objective 12, policies 12.1, point 2, point 3, and
Yes.
point 4. End. Strike policy 12.5, point 6, and point 7, and point 8. Those are no longer, we moved those over from existing
Right.
future land use. Take those out altogether. They're not required. We're going to just do what the state is making us do, which is 1 through 4, and we'll leave it open. Done. Easy.
So,
Which is exactly what 1,000 Friends of Florida says is the minimum to suffice.
Right.
so,
And then,
wait a minute here,
That was Commissioner
12.5. I'm just reading 12, I'm just rereading this. Just, if you give me 1 second, please. So this 12.5, well, I'm guessing 12.5 was required by Florida statute 7051 at one point, and is not required now?
it wasn't ever required. I was our city's good, we were a model child, according to the state. We weren't the target of this property rights element stuff.
And that's what
So
I'm
why
trying to,
would we
that's what I'm
remove
trying to
it?
clarify too. By not adopting 12.5 in this ordinance, are you telling staff to remove it from the other location in the
Yes.
comp plan?
So my motion would
Because
be,
it's already in the comp plan.
my motion would be to strike, as staff has recommended, strike the future land, the private property rights language in policy 1.A7.7 from future land use element and
Adopt 12
adopt
under 12.4.
element 12, its own property rights element as laid out here with goal statement 12, objective 12, and policies 12.1 through 12.4, and no longer. And then,
Are we removing property rights by removing this?
no, we're actually, like,
Exactly what the state's.
we're complying fully with the state, and it's much cleaner and easier.
Okay, well, I just want to make sure we're not removing anybody's property rights, so.
Is there a motion and a second?
But I will also, I'm just gonna also add, I've saw a lot of things in the 1,000 Friends of Florida, especially in objective 3 with the four out of 5 votes, so the supermajority would never vote for that. And most of objective 2, the policies, I thought were exclusionary and would add tens, if not hundreds of thousands of dollars of cost to any home built in the city.
I think that's why staff appropriately said, let's really
And
take it
that's-
slow and
it's-
careful.
It would just, the regulatory cost to that, to every home, would be overwhelming.
Cool?
Then let's keep it
Short and sweet.
simple, which was their recommendation. And
Can I have the motion person and the second person again?
It's me. I'm the motion maker, Commissioner Meyer.
And
I
who's the
second.
seconder? Vice Mayor?
yes.
Any other discussion before I go to the public?
Wait a minute, do we need a dual motion to also approve the changes to the marine industrial?
You can either include it in your motion, but you're absolutely right, we did not address it.
Okay, I also approve,
But he struck all the rest.
but I changed the ordinance.
everything
I
other than
I
what you
struck a
approved.
bunch of stuff. So yes, I also moved, included in that motion is the staff's recommendation to modify the table of densities and intensities with respect to marine industrial. Yeah?
Second.
Okay.
I mean, I'm remodifying my second.
Clerk, do you understand what's going on?
Yes.
Everything is clear?
Yes.
Members of the public, do you have a comment on ordinance number 2473 20-21? Would you please state can you help conduct them towards us, Mr. Paul?
Hello.
Yes?
Sorry, Marcella Camblor for the record. I support
Commissioner Meyer's motion. I have been following the House bill that triggered these required comprehensive plan amendments. I've been doing this for a number of local governments in the region, much like the current motion on the floor. All local governments in our region are following the Keep It Simple recommendation. The House bill that initiated the property rights amendment intent really backfired a little bit because the result was, planning came to almost a halt everywhere in Florida because local governments had to deal with this language. As Commissioner Myers said, Florida League of Cities got together, proposed language, which your staff has brought forward, and it's what you're going to adopt. So I commend you for that. League of Counties did the same thing. It's not just the Treasure Coast Regional Planning Council, but all 11 regional planning councils have, it's unusual for all of them to recommend the same thing, but have recommended to keep this simple because otherwise, again, the intent would have backfired. And if there's issues you have to, come back and take a look at in the future, you absolutely can. But I have to say that most of the cities and counties in our region have already adopted the very simple version of the language that you're proposing. So that's it, just supporting that. Late enough at night, I feel strongly and passionately about this. So thank you.
Thank you, Ms. Gambler. Any other comments by the public? Any other comments by commissioners as to this item? Staff, do you have any further words on this item?
No, Madam Mayor.
Clerk?
Commissioner McDonald?
Yes.
Vice Mayor Matheson?
Yes.
Mayor Clark?
Yes,
Commissioner Bruner?
Yes.
Commissioner Meyer?
Yes.
thank you. Would anybody like to adjourn this meeting?
You guys got a lot done tonight.
Thanks, guys.